yourself that we adjourn midday to attend to personal matters, and also not to sit tomorrow and Wednesday, also to attend to matters pertaining to your office. Good morning, and remember, you continue to be under oath.
I do. Thank you, Chairperson.
Thank you. Advocate Gaitobi,
Thank you, Chair.
the stand is yours.
Thank you. What we have done is that we have pulled various parts of the record into a cross-examination bundle to make it easy to page through it rather than moving from page 1002 to page 2002. Could I just ask my team to put those in front of the panel and in front of the witness, and of course to my learned friends?
Thank you, Council. You may.
Thank you. Well, I'm told it's also uploaded electronically. So for those where they don't have individual hard copies, it's accessible. If the panel has file 1 and file 2 of the cross-examination bundle.
I beg your pardon. I have file 1 and file 2. My sister has file 2, file 2.
All right. No surprises there. Thank you, Chair. I may commence then.
Thank you.
Thank you. Advocate Patoy, I understand that you started as the NDPP on the 1st of February 2019. Is that correct?
That is so.
And in your evidence, you stated that one of the cases that you inherited was an application for the judicial review brought by Major General Boyson against the racketeering certificate, which had been issued by Advocate Sean Abrahams. Is that correct?
That is correct.
Yes. Then you also stated that you instructed a panel led by Advocate Rodney de Kock to review the evidence and to give you advice on the way forward. Is that correct?
That is so.
Yes. Then Advocate de Kock gave you the advice on the 27th of June 2019. Is that correct?
I don't have the report in front of me, but I have no doubt that that's correct.
Yes. After you received the report, you withdrew the opposition to the case.
That is correct.
Yes. Now, there's something that doesn't make sense with this narrative. I presume that the NPA had senior counsel on brief to defend the application. Is that correct?
I beg your pardon, Council. You take it slowly.
Thank you.
Take it slowly. The withdrawal of the matter following Advocate de Kock's report pertains to the Katomena matter.
Yes. Yes. Thank you. Now, Advocate Bahuto, there's something that I need to get clarification because it doesn't appear to make sense to me. I assume that the NPA had briefed senior counsel to defend the application by Major General Boyson. Is that not correct?
My recollection is that is the case.
Yes. Now, did you take advice from the senior counsel on the prospects of success in defending the application?
I don't think so.
Well,
I'm trying to think back. I'm trying to even think who the counsel was.
Well, I can tell you who the counsel was. It was Advocate Hilton Epstein.
That's quite possible because he was dealing with a number of matters at the time.
Well, I've got this information from Advocate Sean Abrahams. He had briefed Advocate Epstein. Now, you haven't answered my question. Did you take advice from Advocate Epstein or not?
No,
All right.
I don't think so.
All right. And did he give you any written advice?
I can't recall.
Advocate Batoy, it can be no, and you can't recall at the same time.
Well, I can't recall whether he did. And it's difficult trying to cast your memory back a number of years. I know he was dealing with a number of matters, and this is, as you say, one of them. I honestly can't recall whether he did give any advice.
The problem I have is that you've disclosed many legal opinions, and you have not mentioned Advocate Hilton Epstein at all in your evidence in chief or in your statement. So I'm wondering, why have you suppressed that information?
I haven't suppressed anything. I honestly can't remember whether he gave us any opinion on this.
But nevertheless, it seems to me that a responsible NDPP would have asked the senior counsel on brief for an advice on the prospects of defending the application.
In my view, I had the opinion of a very senior, experienced team from the NPA, and I accepted their advice.
I'm talking about before you obtained the opinion of Advocate de Kock. Advocate de Kock gave you an opinion only on the 27th of June, but you had been seized with the matter as soon as February 2019. I'm asking you, you've said initially you did not obtain advice. Later you said you don't recall if you obtained advice, but I'm asking you, it seems the most prudent thing would have been to ask the advocate you have briefed for advice. Why did you not do that?
In my view, the most experienced persons to give me advice on this racketeering issue would be persons in the NPA who are experienced with racketeering. And that is why I decided the most appropriate and reasonable way would be to get not just one person, but a panel of 4 people, very experienced in these issues, to give me a view on this.
Yes. And I just want to make sure that I've given you a fair chance on the question whether you did or did not obtain advice from Mr. Hilton Epstein, because I'm going to ask the panel to give me a chance to consult with him and to ask him whether or not he gave you advice. And you've given so far 2 inconsistent answers. One, I don't remember. Other, no, he did not give me advice. Do you want to consider your position?
No, I really am trying to think about what happened at the time. My initial response was, in fact, I really don't remember, but having thought more, I'm inclined to think that I did not get it from him. But of course, you are most welcome to speak to him, and we will also check our files to see if there's anything to that effect. But we're certainly not suppressing anything.
Now, my instructions are that, in fact, there was a meeting with Mr. Epstein on the 6th of March, 2019, called by you at your office, which included the state attorney, Mr. Sebele Metza. Do you remember that?
I did have meetings with Mr. Epstein.
You did have meetings with him?
It may have, in fact, been more than one, because he had been dealing with a number of matters in the NPA. And so I just wanted an update on what was going on.
Yes, I'm asking you about one meeting, which is the 6th of March, 2019. Not asking you about other meetings.
All I'm saying is that I did meet with him, and that is possibly also a date on which I met with him.
Now, that meeting, I understand, was also attended by Counsel for Major General Boysen, Advocate Anton Katz. Do you have any comment on that?
Unless my memory is failing me, I can't recall having a meeting with Katz and Epstein. But I'm not saying that it didn't happen, but I really, at this point, I can't remember that.
Well, it would have been a big story on your diary that you have called the advocate who represents the person who is suing the NPA into the same meeting with the advocate who's defending the NPA. I'm not understanding why you cannot remember such a big event.
Well, it may be a big event in your calendar, Advocate, but for me, I meet with lots of counsel, and I cannot recall whether they were both in the same meeting.
So your answer is, I don't remember.
That is correct. I do not remember.
Just like you don't remember if you got an opinion from him or not.
That is correct.
Yes. Now, I am also told that it was at that meeting that you instructed the state attorney to withdraw the opposition to the Major General Boyson application.
What date was that?
6th of March, 2019. I presume you also can't remember.
I can't.
Yes.
I beg your pardon. The answer, if I understand it, is that you don't remember the meeting
No,
where
whether
Advocate Katz was present, or what is it that you don't remember?
the last question was whether I gave an instruction to withdraw the opposition to the review application on that date. And I cannot recall that.
Yes. Can I ask you then, Advocate Batoy, because legal opinions are privileged information, can I ask Advocate Epstein to give me from his records the advice, if any, that he gave you?
This is an inquiry seeking to establish the facts. I have no issue with that.
Yes. Oh, thank you. Because it seems to me, if your evidence is that you only took the decision to withdraw the opposition on the 27th of June, after the 27th of June, that would be fundamentally inconsistent with the facts as they happened, which, as I understand, already that decision was taken by the 6th of March, 2019. Would you accept that?
That would be inconsistent, yes.
Yes. All right. We will come back to that topic after I have spoken to Advocate Epstein. Can I ask you another topic? You have repeatedly mentioned state capture in this inquiry. Do you remember that?
I do.
Yes. Now, the definition of state capture as adopted by the Commission under Justice Sondo is a misuse of the state and its organs for private gain or for unlawful aims. Do you accept that definition?
Yes.
Do you have any personal knowledge that Advocate Chauke was involved in state capture?
I don't have any personal knowledge.
Yes, all right. So then it was grossly irresponsible of you to mention state capture in the context of Advocate Chauke when you have no personal knowledge of his involvement in state capture.
Should I comment on that?
If you want to, I'm putting it to you that I will argue that you were attempting to poison the atmosphere when you had no evidence, but you mentioned state capture together with Mr. Chauke.
The reason why I did is that I was asked about why I took certain actions when I did. And I explained that because that was in fact the NPA and capture of the criminal justice system was something that the Zondo Commission was inquiring into. And I couldn't turn a blind eye to the fact that that was what was being inquired into, and that as a responsible national director, in my view, I needed to consider all options. And the only reason why I mentioned it is because I was asked about the context and why I took certain actions. And that was what was also something that was on my mind at the time. So I considered all of this, and therefore I took certain actions.
Advocate Batoy, we are in an inquiry against Advocate Chauke. We are not in a state capture inquiry. My question was simple. You've given me an answer. You have no evidence that Advocate Chauke was involved in state capture. Yet you have repeatedly mentioned state capture in the context of this inquiry into Advocate Chauke. That is what I am saying to you, is intentionally designed to poison the atmosphere of this inquiry, to create the impression that Mr. Chauke is involved in state capture, when you know full well that you have no such evidence.
I was asked what were the reasons for me doing certain things at the time. And I explained that that was the context within which I took those decisions.
Yes. Anything else to add?
No.
Now, can I then move on to another topic, just to understand these charges? My understanding of the way in which these terms of reference emanated is that you drafted them and the president endorsed your draft. Is that correct?
Well, actually, what happened is we went and checked this after. We did submit a draft to the president, but what the president adopted subsequently is quite different from the draft, and we didn't input into any draft that the president had. So there is a difference between the two.
All right. Well, I have not seen the draft you gave the president. And maybe you should send us that draft, because I understood all along is that the president endorsed the draft that you gave to him.
No, that's not the case. We can let you have the draft.
Yes. Now, can I then go to making sure that I understand?
I beg your pardon. Advocate Batoy, what is the answer? You're saying Advocate Toby can have the draft.
That is correct.
Do you have it?
We do have it.
Thank you, Madam Chair.
Has it been made available to the evidence leading team, that draft?
I'm not sure if it has.
May we ascertain whether the draft document that was sent to the president as regards the terms of reference has been made available to the team? May
Sure.
I just verify with Advocate Mutlamanyane? Has it been made available to you?
Madam Chair, I'm not aware of any draft. All what I'm aware of are the terms of reference that have been gazetted.
Might we find out from your team, Advocate Halley and Junior and the lady next to you, if you probably have the document in your possession? It may also be relevant, I'm not sure at this stage, because you have raised, Advocate Batoy, a question of the correctness of not necessarily that way, because you seek to amend the terms of reference, correct?
That is correct, Chairperson.
That document may be relevant in determining what you conveyed to the state president.
Sure.
May it be made available if you have it, Madam Advocate Halley and Junior?
Madam Chair, we no doubt will make it available, but my instructions are, and I've got to verify this, but my instructions are that it already is there, but I stand corrected. I would have to verify it myself.
Do you have it though? Do you have the document?
Not at this speed, right?
Not at this stage.
Yes.
Are you making an undertaking, Advocate Batoy, that your office will make available the initial letter or document, whatever it is, or a memo to the state president?
Yes, we will.
When will we have the document?
Today, as soon as we are adjourned.
is thank you. Will it help, Advocate Ntwetuli?
Yes, Madam Chair, it will help. I still have one more question on the issue of this draft. Advocate Patoya, I want to confirm whether it is your testimony that the draft you gave to the President is different to the terms that the President finally signed.
That is correct.
Yes. And you cannot at this stage tell us what the differences are.
I can't.
Yes. All right. Can we then go to the terms of reference that the President endorsed? Because I am not understanding them. They have been referred to in several parts of the case. Hopefully the panel can access the terms of reference easily.
I'm trying to find my copy, Chairperson.
Do you have the copy,
I don't have it yet.
Advocate Mutlamunyane? Do you probably have a copy that we can give to Advocate Batoy? A copy is now made available.
I do
to
have a
us.
copy.
Thank you.
Thank you. Can you go to item 3.1.1? It reads, the institution of the racketeering charges in terms of Section 2, subsection 4 of the Prevention of Organized Crime Act 1998 against Major General Boysen and members of the Ketumano unit, and the defense of those actions in subsequent review proceedings brought by Major General Boysen to have the racketeering certificates set aside. In that, now there are a couple of points that arise from that. The first one, is that charge limited to racketeering or does it include the predicate offenses?
Racketeering, by its very nature, includes predicate offenses.
Yes, but you know what I'm asking you. I'm asking if the murder charge standing alone is included or excluded. And if I can give you an example to make it easy, Major General Boysen is charged with 7 counts, 2 of racketeering, 2 of murder, 1 of defeating the ends of justice, and 2 of violating the provisions of the Firearms Control Act. My question is a simple one. Does that charge exclude the 2 murder charges, the 1 charge of defeating the ends of justice, and the 2 charges of violating the Firearms Control Act?
As I said, racketeering by its very nature includes the predicate offenses. So it must include the predicate offenses as well.
Advocate Batoy, please answer my question. I am not asking you about racketeering offenses and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Boysen.
It does not exclude it in the context of racketeering.
Advocate Batoy, I think we are going to be here for a long, long time if you don't answer the questions directly. We know racketeering, in order to establish, requires predicate offenses. That's not what I'm asking you. But I'm asking you is that Major General Boysen was charged independently of murder. Is it suggested in this charge that he should also not have been charged of murder independently of racketeering?
That's not what I'm saying. What I'm saying is that I can't, that's my answer, is that the predicate offenses are included in the racketeering charge. And so my understanding is that he would have been charged for those predicate offenses in the context of racketeering.
I honestly do not understand that. And let me give you a final chance. If you withdrew racketeering, Major General Boysen will still face a murder charge.
That's a different question, and I'll answer that now.
Yes,
So
now-
when I did withdraw the racketeering,
No, I'm not asking you to answer anything. I'm telling you the question that I'm going to ask you. Is 3.1.1 intended to suggest that Major General Boysen should not have faced the murder charge?
not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offenses outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Boysen to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Boysen.
Yes. Those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Boysen with murder?
My understanding is that Major General Boysen was charged with racketeering and that those were the predicate offenses.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
I beg your pardon, Advocate Koitobi. Is this question premised on the assumption that Advocate Chauke made a prosecutorial decision to charge?
Yes, I'm working now on the best case for the NPA.
That's why I'm asking the
Yes,
question,
no,
because all along, when we read the opening address, it seems to me that there was an issue regarding whether he made a prosecutorial decision
Yes.
in relation to the Katomena matter. My understanding of the evidence favorable to you was that Advocate Chauke was appointed merely as a coordinator in relation to the KZN Katomena matters.
Yes.
That's why I'm asking the question as to whether you premise this question on the assumption, at least for now,
Yes.
that he did
Yes.
make this particular
Yes.
prosecutorial decision
Yes.
as regards the charge of murder against Major General Boysen.
Indeed. I'm working now, Madam Chair, on the best case for the NPA, that Mr. Chauke has taken all of the decisions they claim. I'm trying to understand the substance of the complaint, but I will still deal with whether he did make those decisions or not. So I'm still trying to analyze the charge. Let's come back then, Advocate Betoy, to understand what 3.1.1 is about. You have said that your understanding is that murder featured only because it was a predicate offense, not because it was an independent offense. Is that correct?
It was a predicate offense to racketeering, that's correct.
Yes. And therefore, it is irrelevant to Section 2, subsection 4 as an independent offense. It is only relevant as a predicate offense.
That is correct.
Yes. All right. Now, the reason I'm asking you this is because even on your own version, you've accepted that at least in relation to one of the charges, there was sufficient evidence to prosecute. Is that correct?
No, I'm not understanding you.
Well, you've told us that you gave all of the dockets to the DPP of KZN. She enrolled one case against Mr. Padiache on a count of murder. So she must have considered that there was sufficient evidence to charge Mr. Padiache with murder.
Yes, I didn't realize you were referring to that docket. That's correct.
Yes. That's why I come back to say, in at least one of the cases, there was sufficient evidence to proceed with a murder charge.
That's correct.
Yes. Now, that distinction is not made clear at all in 3.1.1. If you read 3.1.1, it suggests that in none of those cases, there should have been a charge.
Against Major General Boyson. That's what that suggests.
No, that is false. It says Major General Boyson and members of the Cato Manor unit.
Let me read this carefully.
Mr. Padayache was a member of the Cato Manor unit.
The point I made earlier is that this related to racketeering charges. And therefore, it's clear here that this section is relating to racketeering charges and murder as a predicate offense and not as separate independent charges. And so it's correct in that regard that it is racketeering. It doesn't refer to murder at all.
Yes, I thought we had moved from that question and we were debating the independent charges. And I asked you a question, whether you would accept that in at least one of the dockets, the case against Mr. Padiache, there was sufficient evidence to charge. And I understood your answer to be yes.
That was my answer.
Yes. And when I proceeded with that, you said, well, exclude Major General Boyson. And then I pointed to you that actually exclude all members of the Cato Manor unit.
The point I make is that whether it's Major General Boyson or all members, this particular paragraph refers to racketeering charges and not independent murder charges.
Yes. Now, could I then ask you to turn over the page? 3.1.1.1 refers to supporting a decision to prosecute the accused. Who is the accused?
All the accused in the racketeering charges.
Yes, that's where we come back from, where you say no evidence justifying the decision. And now we understand that you would accept in relation to one, that there was evidence justifying a murder charge against Mr. Padiache.
But not a racketeering charge.
Yes, I understand.
Anyone.
You've made that clear. I'm asking you a different question. Was there sufficient evidence, in your opinion, having studied the dockets, if you did, to support a murder charge against Major General Boyson?
There wasn't.
There wasn't. Now, you gave evidence earlier that you did not study the dockets and you relied on a memorandum by Advocate de Kock. Was that evidence accurate?
That's correct. But my answer now also relies on the evidence of a report of the DPP KZN.
Yes. I'm not asking you about the DPP KZN. I'm asking you, at the time you took the decision to institute a disciplinary case against Advocate Chauke, you relied on the report of Advocate de Kock. You never studied the docket. Is that not correct?
That's correct. I didn't, let me just check the time that I decided. No, that's correct. I didn't study the dockets, the 23 dockets.
Yes, I'm asking just the docket around Major General Boysen. 2 murder charges, 1 charge of defeating the ends of justice, 2 charges of violating the Firearms Control Act. Can I tell you, Advocate Chauke read the docket. Did you know that?
I would have expected him to.
Yes. But you have come to say to the panel, there was no case against Major General Boysen without ever having read the docket. Can I suggest that that is an astonishing proposition coming from the head of our prosecution service? And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why. There's case law that national directors are not expected to read every single bit of evidence and every docket in cases, and that they are, it's perfectly acceptable for a national director to rely on reports, to rely on presentations, to request aspects of evidence, and to take decisions on that basis. So it's certainly not irresponsible. It is what is expected of a responsible national director.
Yes. But can I also suggest something else to you? That Section 2 of the Prevention of Organized Crime Act is within the exclusive power of the NDPP. Do you accept that?
I'm not sure what you mean by exclusive power, but
Well,
certainly
only the NDPP can sign a racketeering certificate under Section 2, subsection 4. I would have thought that to be obvious.
certainly I agree that only the national director can sign that authorization.
And exclusively the NDPP. No one else can sign a racketeering certificate.
That's correct.
Yes. Now, it's in that context that I say, for you to tell the panel that there is no case against Major General Boysen, also of racketeering, without ever having studied the docket against him, is a grossly irresponsible thing.
I repeat what I said.
Of course.
There's case law that states that a national director is not expected to read every docket and to look at every piece of evidence before coming to that conclusion. A national director, it's permissible for a national director to consider evidence that is presented to him or her by a team, presentations, and to ask for specific aspects of evidence if he or she requires it. But it's certainly not expected of a national director to read every single docket in any context. Sometimes a docket can fill a room, and it's certainly not expected that that is what a national director should do.
Well, can I challenge you on that and put two propositions to you? Firstly, the docket against Major General Boysen does not fill a room. It's a small docket. Do you accept that?
I'm not sure that there is a docket against Major General Boysen. I know that there were 23 murder and other related charges, dockets. I'm not sure that there ever was a racketeering docket as such.
Now, you see, the problem is that you answer, but you always overlook what you wrote. Go to 3.1.1.1. where you say supported a decision to prosecute. I mean, I know you say it's the president who says this, but you never wrote this or you don't know the difference. So I will accept that until I see what you wrote. Your answer remains qualified. That there was no evidence justifying the decision and that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. You are the one who relied on case dockets. Now you are telling the panel there was no docket.
I said there was dockets, there were dockets, lots of dockets, but I'm not aware of a racketeering docket as such.
No, Advocate Batoy, I think there is a real problem. You have said that 3.1.1 is exclusively about racketeering and does not include the independent offenses. And you have also confirmed in 3.1.1.1 that too is exclusively about racketeering. The charge refers to case dockets. What case dockets are those?
Which charge refers to case dockets?
Read 3.1.1.1.
Yes, it does appear there.
It was put there by you.
I'm not sure about that. We'll have to check that.
Yes. But then answer my question, please. The docket that is referenced, we have gone through this exercise ourselves. It is only 7 charges against Major General Boyce. It is not the exaggerated docket that fills a room. What do you say to that?
The only point I made about dockets that fill a room is to make the point that it is not expected of a national director to read every bit of evidence when a decision is made. That's the only reason why I mentioned that. But getting back to this issue, there were dockets relating to, there were the 23 case dockets. I'm not aware. Let me read this carefully before I answer this. This is clearly incorrect because to say that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. It's not our case that Advocate Chauke asked the DPP to sign any case dockets. So this is clearly incorrect. And
so the charge is incorrect.
If I may be allowed to complete.
Yeah, all right, sorry, I thought you had finished. Please continue.
Okay, and or the prosecution memo. He sought to improperly have the acting sign the case dockets and or sign the prosecuting memo. If you read it like that, it's incorrect. That is not what we're saying.
So charge 3.1.1.1 is a wrong charge.
It's incorrect.
Well, incorrect and being wrong are the same thing.
Well, part of it is correct, is that Advocate Chauke supported a decision to prosecute the accused, notwithstanding that there was no decision, justifying no evidence justifying the decision. And then the next part of it is incorrect to the extent that I've indicated.
You see, that's why I need the memorandum you gave the president to see whether the president is at fault for charging Mr. Chauke incorrectly, or whether you are at fault but are now escaping responsibility.
I'm trying to explain as best I can and not to escape responsibility.
Yes, no, I understand that. I'm not criticizing you, I'm criticizing your evidence.
That's fine.
Now,
before you proceed, I think this will also help us, Advocate Batoy. When you look at the gazetted terms of reference, the date is the 30th of September, 2025.
I don't have that gazetted copy in front of me.
The front page of
there you
the
go.
Gazette.
I have it now. Yes, that's
Regulation
correct.
Gazette number 11889, volume 723, 30 September 2025, number 53444. You
That's
have
correct.
that. When did you see for the first time the gazetted terms of reference?
I'm not sure, Chairperson. I can't recall when I saw it for the first time.
Should I assume that by 1 October 2025, you had already looked at the terms of reference?
No, we can't assume that, Chairperson.
Should I assume that by the 17th of October, when this inquiry started, I beg your pardon, by 17th of November, when this inquiry started, you had already looked at the gazetted terms of reference?
Chairperson, I honestly can't remember when I looked at it and whether I scrutinized it at any great detail or cast a quick look through it. I honestly cannot recall that.
When you took oath, the first day you took oath, had you already looked at the terms of reference?
Chairperson, on the first day of the inquiry,
On the first day you took oath,
I would certainly have had a look at it, but I don't know to what detail.
you may proceed, sir.
Just one thing. Advocate Batoi, when the bundles or documentation was prepared for this inquiry, it was prepared with a view to addressing issues raised in the terms of reference. Is that correct?
I'm not aware that it was prepared for that specific purpose.
Did you care to establish as to whether the documentation was prepared for that purpose?
No, I didn't.
Sorry, a follow-up. Advocate Batohi, when you prepared your affidavit together with your legal team, you knew that you were preparing an affidavit to come and testify in relation to the terms of reference in this inquiry.
I knew that I was preparing an affidavit in order to come and testify before this hearing.
Testify in this inquiry in terms of the terms of reference, wherein you referred a matter to the president, who then constituted an inquiry and issued the terms of reference to deal with whatever you referred to the president.
Yes, the terms of reference were for the panel, and of course, evidence was going to be provided to support what's in the terms of reference by various witnesses.
Advocate Batohi, when you prepared your affidavit, you prepared your affidavit to sustain the allegations that you made to the president, which, well, I'm not sure whether rightly or wrongly, convinced the president to constitute a panel. But the president depended on the evidence or on the information that was supplied by you, which you intended to support by way of an affidavit that served before this panel. Is that correct?
I didn't prepare the affidavit with an intention to support the terms of reference. I prepared an affidavit on the basis of what I knew and what I did in this matter. It's not like I prepared the affidavit and then checked whether it's aligned with the terms of reference. That's not what I did.
And what you knew is what you submitted to the president for the president to take a decision to set up an inquiry.
That's correct.
Thank you.
Thank you, Madam Chair. Advocate Batoy, I'm not yet done with this inquiry about case dockets.
Mhm.
You have now testified that the reference to case dockets and trying to get someone else improperly to sign is incorrect. Okay, I'm not going to quibble with that.
Mhm.
But do you accept that the case against Major General Boysen, whether contained in a docket or elsewhere, is a fairly narrow case? It is not the example that you posed of a docket filling up a room.
It's certainly not a docket that fills up the room. That's correct.
Yes. Now, it also continues to say, and or prosecution memorandum.
Mhm.
That's one of the things I don't understand. You never gave evidence in this inquiry that Advocate Chauke sought to have Mr. Molotra sign a prosecution memorandum. Is that also incorrect?
I mentioned earlier that is incorrect.
Yes. So both that case docket reference and the prosecution memorandum are wrong.
It is not our case that Advocate Chauke sought either of those to be signed by Advocate Molotra.
Yes. Now, then it continues to talk about evidence implicating the accused. Who is that accused?
I would imagine it's all the accused.
All of those accused with what? Because there are people like Mr. Mostert, 11 counts of murder. Does it include them or not?
For racketeering charges.
So all of the accused on racketeering.
That's correct.
Yes. Now, the way then it would read is that the case docket would be a case docket for racketeering. The prosecution memorandum would be a prosecution memorandum for racketeering. But because the charge is wrong, we can strike that out. We can put a red pen across that.
Can you repeat that?
I'm saying the way it would read, before your evidence today, the way it would read would be, it's the case docket for racketeering. And then it's the prosecution memorandum for racketeering. But because you have now considered that that is a wrong charge,
I have a case docket for racketeering. I'm aware of a lot of other dockets, the 23 murder dockets and related charges. I don't even know if there was a case docket for racketeering. So I don't understand your question.
well, my question is exactly linked to what you have just said, that you've charged someone for trying to get a signature on a case docket that you say doesn't exist. You've also charged someone for trying to get a prosecution memorandum to be signed, which you admit was never done.
I have not charged anyone for that.
All right.
I did indicate that that is definitely not the case, and that is definitely an error on that, because there's no evidence at all that Advocate Chauke was required to do any of these either sign a case docket or sign a prosecution memo.
Yes.
The evidence is that he sought Advocate Mlotshwa to sign the indictments.
Indeed, there is not a single charge here that refers to an attempt to sign an indictment. If
That's
you can
correct.
say it, show me.
That's correct, there isn't.
Yes.
And it's not meant to be, because
Yes.
there's no evidence to that effect.
No, I thought you said the case against Advocate Chauke is that he sought to have Advocate Mlotshwa sign an indictment.
That's correct.
I am saying to you, there is not a single charge here that refers to Advocate Chauke attempting to get Advocate Mlotshwa to sign an indictment.
That's correct. I'm not aware of the other, if it's anywhere else on this, but
But
certainly
you
not.
can go through them now, there is enough time, and then show me where it is alleged that Advocate Chauke sought to have Advocate Mlotshwa sign an indictment.
Well, it may or may not be there, but that is our case.
Well, Advocate Batoi, please.
Just before you proceed, just one thing. Advocate Batoi, did you familiarize yourself with the terms of reference?
No, I didn't.
And you are the complainant in this matter?
That's correct.
Thank you.
Well, you can call me the complainant. It's the president that decided. So I'm not sure that I'm the complainant, but I certainly made a referral to the president.
Which question are you answering now?
Whether I'm well, it wasn't a question. It was a comment that I am the complainant in this matter. And I'm seeking to clarify that I don't see myself as a complainant. It's
Thank
the
you.
president who decided. I made a referral to the president.
Thank you.
All right, I'm going to come back to this question by Madam Panel Member Ramaphosa, but I still want an answer to my question, which is, show me where it is alleged that Advocate Chauke sought to have Advocate Mlotshwa sign an indictment.
I accept from you that it isn't. Otherwise, it's going to take me a while to read this entire terms of reference.
No, it won't take you a while. There are only 5 paragraphs. So you can do that now and tell us which paragraph refers to Advocate Chauke trying to get Advocate Mlotshwa sign an indictment.
May I, Advocate Toby? It's 10:15. And perhaps in fairness to you, Madam, as we take a 15 minutes tea break, you will go through the terms of reference to enable you to answer the question that Advocate Toby has just asked you in relation to whether there is any referral in the terms of reference, if I capture his question correctly, that appears in the terms of reference in the entirety. And when we reconvene, you will then answer the question. Advocate Toby?
Perhaps, Madam Chair, we can also get the draft, because I want to put her draft and the president's decision side by side. If we can get that during this 15 minutes, that would be appreciated.
Yes, I was going to deal with that. You had just mentioned that the first letter to the president, the referral letter, if I may call it that, is readily available. We will appreciate to have a copy of that letter when we reconvene. You can send it to us either online or a hard copy and give it to our researchers. Advocate Toby?
Yes, if we adjourning now?
We will adjourn
Yes.
now. Anything else that
Nothing
you
from
wanted
our
to
side.
mention?
Thank you.
Yes,
Thank you, Madam Chair.
Those two things reflect upon the gazetted terms of reference with a view to answer counsel. Secondly, may we have the first referral document to the president, which you said is readily available or can be made available, so that we deal with this matter when we reconvene. Thank you. We will adjourn for 15 minutes for tea and reconvene at 10:30.
we adjourned, I had asked you to study the whole charge sheet and to tell us whether or not there is an allegation that Advocate Chauke sought improperly to get Advocate Mulotshwa to sign the indictment.
There isn't.
Thank you very much. Now, can I ask you about 3.1.1.2? It says that presumably you recommended to the then acting National Director of Public Prosecution, Advocate Nomgcobo Jiba, the application for issuing a racketeering authorization in terms of Section 2.4 of the Poker Act, whereas there was no evidence justifying the institution of racketeering charges against the accused. Now, the recommendation that is referenced there, is it the document we went through repeatedly, which is PP'd by Advocate Chauke? I just want to get
Would you
the...
please repeat your question, Council?
Yes, or maybe what is better is that I must just refer to the document
I think
itself.
that will be helpful.
Yes. My Leonard Jr. will find it now. The question really is this. You had a discussion with Madam Ramaphosa about whether or not Advocate Chauke's recommendation was PP'd or signed by him. I just want to know if the charge is referring to that particular document.
That is certainly one of the documents it will be referring to. I'm not sure if it's the only one.
All right, let me find the specific document right now, because you might help us on that. But the second question I have, I'll come back to this as soon as we find it.
I think I should try to find it as well. Chairperson, if I can get some assistance so that we have the documents ready through you, Chairperson. I'm not sure where these
Indeed.
documents are.
Yes, Madam. Advocate Hali, where's your junior? She doesn't appear to be here.
I believe
They're trying to find their documents.
She's trying to find the document.
Yes.
But I will obtain that document because I think I've got it.
No, my junior was quick on the mark. It's LO 00780.
M
LO
LO
00780.
80.
Yes.
Is that an internal memo from Advocate Nokumashilu to Advocate Jiba?
Yes, Madam Chair.
Yes, thank you.
Yes. Dated the 15th of August, 2012. Now, the reason I ask...
May we wait for Advocate Batoy? Do you have it?
I do have it now.
You
Chair.
have it,
Yes.
Madam.
Now, the reason I ask Advocate Batoy is that it is the only document I could find that uses the word, I have perused the documents and recommend the application. And when you look at what is recommended is at 1.3 are the draft authorizations for Section 2.1E and 2.1F of POCA. Is that what you are referring to in 3.1.1.2?
This is definitely what we are referring to.
All right, that's fine. We can note that that's the document you are referring to.
I didn't say it's the only document, but it
Well,
is a document that
show
we're
us
referring to.
any other document.
I'm
that-
not sure if it's shown to me, then I might be able to comment on it.
Well, in your evidence in chief, you did not make reference to any other document. In our own search, we did not find any other document where there is a recommendation for the signature of the racketeering authorization, other than that document that involves Advocate Chauke.
I think there's another document that's prepared in his name, but is not signed by him.
Yes, exactly. That is the only document that he signed. I know what I'm asking you.
Mhm.
So I come back to my question. This is the only document we could find that is signed by Advocate Chauke.
Relating to the racketeering authorization.
Well, that is obvious, Advocate Batohi, please, because I am talking about 3.1.1.2, which is about the racketeering authorization.
No, with all due respect, I don't want to take, things may not be that obvious. So I want to make sure when I answer, we're
All
clear
right,
about what
I
I'm answering.
apologize. Yes, the answer is yes.
So in this case, it does relate to the authorizations for racketeering. That's correct.
Yes. Well, let's make this clear because I Advocate Chauke, which reference authorization under Section 2, subsection 4 of POCA. Is that correct?
That's my recollection.
Yes. Thank you very much. Now, with staying on 3.1.1.2, that charge has nothing to do with the predicate offenses independently. I understand that predicate offenses are part of POCA, but it has nothing to do with the separate charges. It's limited only to Section 2.4. Is that correct?
That's correct.
Yes, thank you. Now, if we could also analyze 3.1.1.3. It says Mr. Chauke sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that he finalized the answering affidavit of the then acting National Director of Public Prosecutions, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, is it the case of the NPA that when it says Mr. Chauke defended those proceedings, it is referring to the role he played in the preparation of the answering affidavit of Advocate Jiba?
It is definitely that.
Yes. Yes, but there is nothing else. It is only that.
I'll have to think about the evidence carefully. I've laid a lot of evidence, and I don't want to concede that it's only this if I haven't really carefully considered what the evidence is. So I need to think about this.
Advocate Batoy, you have spoken in this inquiry, I think, for 12 days. For you to say you still have to think carefully about the evidence really sends a negative signal.
That's your opinion, Advocate.
But I presume you have thought about the evidence you've given for the last 12 days.
I certainly, it's been something that has been consumed me for the past 12 days, but there's a lot of evidence. So I need to be careful when I say it's the only evidence because there's a line, so I need to think about this. I don't want to concede and then there's something else. So I should be allowed to think about this carefully.
I'm not asking you not to think about it, but I am putting to you that before you gave the evidence, you should have thought about it. You cannot be asking to think about it during cross-examination.
That's your view. I'm going to think about it anyway before I answer your question. So this is definitely one of the aspects of his defending the institution of racketeering. I'm trying to think about whether there's anything more in this respect.
Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing.
If I may on that point say that the chapeau to these charges, if we want to call them charges, for want of a better word, states at 3.1, his direct or indirect conduct should be the direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to the matters related to the following allegations. And my point is that in as much as these attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this.
Well, this is what I'm debating with you, Advocate Batoy. What is the indirect conduct that is referenced?
So I need to think about all the evidence that I've provided thus far.
But I'm asking you, I'm putting to you that the charge is 3.1.1.3. You are saying in answer to me, no, look at indirect evidence. And I'm asking you, what is the indirect evidence?
With all due respect, I didn't say look at indirect evidence. What I said is that I was reading out the chapeau, and I said it states including but not limited to matters related to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.1.1.1 until 3.1.1.5.
Now, what are the other allegations that are not included? What we cannot have?
For example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Malochwa to sign the indictment, that should have been included here.
Please, Advocate Batoy, we are at 3.1.1.3. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that that scope is limited. You're saying it's unlimited. I'm asking you, what are the other facts that support the defense of that review application?
I don't know for now if there are any other facts.
Thank you very much. Can we then go to a second aspect of that charge? You know, the last line, which starts with of racketeering charges against the accused.
I beg your pardon, Counsel, to interpose. The question that you asked Advocate Batoy in relation to the specific aspect, that is the scope of 3.1.3. Might we look at page 66 of the affidavit? It might help us. Page 66 of the record that contains your affidavit, paragraph 156. You have it, Advocate Batoy?
In a moment, Chairperson. Yes, I'm there.
Paragraph 156 of your affidavit gives us the essence of the allegations against Advocate Chauke. And for the purpose of the last question by Counsel, we may look at 156.4. You remember that?
I do,
You
Chairperson.
see that?
Mhm.
And by mere looking at paragraph 1556, giving us the essence of those allegations against him, that is Advocate Chauke, the essence is there.
Mhm.
And it includes 1564 to the extent that he settled the affidavit of Advocate Jiba. And there appears to be nothing more in that paragraph 156 as regards the question that is put to you. Am I correct?
This is the essence of the allegations, indeed, Chairperson, which is summarized in this paragraph.
I am specifically referring to 156.4 as regards the question that is put to you regarding the conduct of the alleged conduct of Advocate Chauke in settling the answering affidavit of Advocate Jiba. And I'm asking, is it correct that there is nothing more to this paragraph 156.4 in this affidavit? Your affidavit?
Chairperson, I'm not sure if there's nothing more because this was, as I said, summarizing the essence of the charges. I don't know if this is dealt with anywhere else in the affidavit.
This is your affidavit, Counsel, with the greatest of respect to you. You should be able to help us because it is your testimony. You should know this affidavit better than us. It is your affidavit under oath. Otherwise, we are going to have to adjourn again and read this affidavit so that we ascertain whether there is any other part in your affidavit that makes reference to the further conduct of Advocate Chauke that is impugned.
I'm trying to go through the affidavit quickly, Chairperson, to the other sections and look at whether it was covered, because I know when we were drafting it, we dealt with the allegations and then we summarized the essence. So I suspect that it would be covered somewhere else as well.
I request the lady next to you and the junior counsel over there, if there is anything else that you might have picked that may be of help to Advocate Batoi, don't hesitate to bring it to her attention.
Yes, if they could check in the electronic version, it will be easier perhaps.
You may quickly, counsel, look at the electronic version.
I'm advised 146 might be applicable. 180. 180. 180.
I think 146 is just a replica of what is stated in 156, the essence
Okay,
of the two.
146.
146 reads, in response, Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him. And that reiterates what appears as an essence at paragraph 1564.
That's correct, Chairperson. I'm checking 180 as well. Mm. 180.8, I think, Chairperson. Those are the only places. Those are the only three places. Okay. Those are the only other places that they can pick up electronically, Chairperson. And so we should accept that those are the only places where this is mentioned.
One
0.8.1.
8, page 76 of your affidavit. The heading there read, there is prima facie evidence that Advocate Chauke was complicit in the fraud and perjury charges leveled against him. And 188.1 reads, Chauke deposed to a confirmatory affidavit in the GCB case, where he confirmed that he finalized Advocate Jiba's answering affidavit before Groven's judgment gave rise to the fraud and perjury charges against Advocate Jiba. I suppose the point that you are referring to is the first line of 180.8.1. That again, and not necessarily so, that he deposed to a confirmatory affidavit, supposedly following the answering affidavit that you relied upon earlier. Is it a different matter?
No, it's the same matter, Chairperson.
Thank you.
Thank you, Madam Chair. I think could we just come back to this topic, because I'm just not sure if there is any difference. Let's start with 3.1.1.3, which is the charge. Okay. Now the charge says you sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that you finalized the answering affidavit of the then acting National Director, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of the racketeering charges against the accused. Now, my question to you was, my reading of this charge is that the scope of that charge is limited to the role Mr. Chauke played in the preparation of the answering affidavit of Advocate Jiba. Your answer was no, it may be broader than that. That's where the discussion started. Now, the chair then intervened to say perhaps your affidavit can shed more light. Now, let's look at each of the paragraphs you've now cited, starting with 146. Now, paragraph 146 reads, in response, Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him, would you accept that that is the same as 3.1.1.3? It does not add any additional facts.
That's correct.
Yes. Now let's go to paragraph 156. Now, paragraph 156, the relevant part, as pointed out by the chair, is 156.4, which says he settled the affidavit of Jiba, and the allegations contained in Jiba's affidavit were found to be false, and as such, he had made himself party to those false allegations. But the conduct is still the same. It's the role he played in the finalization of the answering affidavit. Is that correct?
That's correct.
And then the last one is paragraph 180.8.1, which reads, Chauke deposed to a confirmatory, should be a confirmatory affidavit, in the GCB case where he confirmed that he finalized Advocate Jiba's answering affidavit before Governor J. Govern's judgment gave rise to the fraud and perjury charges against Advocate Jiba. Again, would you accept that the conduct is still the same? It's the role of Mr. Chauke in the finalization of the affidavit by Advocate Jiba.
That's correct.
Yes. We can then come back to where I started. There is no other case that Advocate Chauke is other than the role that he played in the finalization of the answering affidavit of Advocate Jiba. Is that not correct?
Yes, let me just say that there's different actions that Advocate Chauke took in this process. For example, liaising with the team and Advocate Hodes, but it's all in relation to the finalization of this affidavit.
Yes, but I've never asked you about those sub-steps. I asked you that the conduct you are worried about is the role he played in the finalization of the answering affidavit. Obviously, he did many things, including signing a confirmatory affidavit. But what I want us to agree about is that that charge, the scope of it, is limited to the role he played in the preparation of the answering affidavit.
I'm trying to answer this in a way that conveys not precisely, because it's difficult to be precise, but conveys the full scope as has been put to me of his conduct in defending the racketeering charges. Certainly the finalization of the answering affidavit is an important aspect of that conduct, and is the one that is referred to in this subparagraph, or 3.1.1.3. And I hear Advocate Gaitobi saying that he doesn't want the steps, but it relates to the scope. That's the conduct broadly. And so to that extent, I can agree that it relates to that conduct.
Yes, now, thank you. Now, the charge is even more limited because it is about the finalization of the answering affidavit. Now, you have other things you wish to add to the charge, but they're not in the charge.
So as I mentioned earlier, I have testified about what I know and what I've experienced and what I've found in this process. And I'm not attempting to add anything. I am giving evidence. And in my view, it is because of the chapeau 3.1, what I'm saying is admissible and should be considered, because these sub-paragraphs, if you want to call it that, 3.1.125, are not limited. And so I'm giving evidence about what I know and what I've experienced, and that's all I can do here.
Advocate Batoy, you are still not answering my question. The question is straightforward. That charge, I know the word charge is a strong word, but it was introduced, thankfully for all of us, by the chair, refers to the finalization of the answering affidavit. Doesn't refer to these other steps you are talking about.
But it includes them.
Where does 3.1.1.3 include them?
I said the chapeau includes them.
Yes. So the preamble.
Yes, 3.1.
Yes. Now, we are still to look at what the draft was. Because it seems to me that the simplest thing would have been to tell Mr. Chauke that you are accused of preparing the answering affidavit. You are also accused of the following preparatory steps, because that is all information that was within your knowledge when these charges were prepared. Is that not correct?
It was within my knowledge, that's correct.
Yes. And now, why don't you include it in 3.1.1.3?
If we wanted to include everything, we would have had to include Dr. Broughton's bundle as the charge sheet, because it has lots of conduct of Advocate Chauke that would fit into some of these, like his role in preparing the answering affidavit.
But Advocate Batohi, I'm asking you about one aspect. I've not even come close to Dr. Broughton. I'm asking you about the preparatory steps that you have sought to add to 3.1.1.3. Why were they not reflected? It would have been one sentence in 3.1.1.3.
I can't answer why it was not included, but that's my evidence.
Thank you very much. Then I said to you that there was a further aspect of this charge when in my analysis I couldn't understand. It talks at the end, in the last line, with racketeering charges against the accused. Now, on the one hand, it may appear to refer to all of the accused. And on the other, it may appear to refer only to Major General Boyson. Does it refer to Major General Boyson only, or does it refer to all of the accused?
I'm looking at the context of this charge, and well, for want of a better word, and the way it's framed in order to answer your question. It says here, he finalized the answering affidavit of the then acting NDPP Advocate Chiba in the Boyson review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, given that it is referring to the Boyson review application, my interpretation of that would be that it refers to Boyson alone.
All right. So unlike 3.1.1.1, which you said refers to all of the accused, 3.1.1.1.3 refers only to Major General Boyson.
Yes, that is correct.
Yes. And can you explain why it did not say against Major General Boyson?
I can't.
Because that, again, would have been a very simple insertion. You would accept that?
To the extent that it's relevant, it would be a simple insertion. But
Well,
it doesn't make a difference to what's said there.
Well, okay, let's talk about the relevance. It's clearly relevant to tell Mr. Advocate Chauke what the scope of the allegation is. And if the scope is limited to Major General Boyson, it's relevant to tell him that. Wouldn't you accept that?
Well, in this context, it is telling him that.
Yes. Now, if you look at 3.1.1.4,
Marcel, before you go there, and Advocate Batoyi, this is just a clarity-seeking exercise on my part. Whilst we are still on 3.1.1.3, look at paragraph 142 of your affidavit. It's on page 60.
Mhm.
This paragraph refers to the unlawful action on the part of Advocate Chauke as the de facto DPP. You remember?
Mhm. I do.
That was your evidence. And now, when we unpack this allegation or this statement on your part relating to the unlawfulness or the alleged unlawfulness on his part, I suppose we should then go to the terms of reference 3.1.1.3 that we have just been talking about, and try to relate it to what you allege to be an unlawful action on his part. If one were to look at 3.1.1.3 regarding his having finalized or settled the answering affidavit on behalf of Advocate Jiva to defend the review application, will that per se constitute an unlawful action? Put differently, will the mere settling of an affidavit on behalf of the head of the NPA in itself constitute an unlawful action? Because what I seek to understand is precisely what is this unlawfulness that you are referring to. Is my question clear to you?
Reasonably, Chairperson.
I beg your pardon?
Reasonably clear. I will try to answer it. Chairperson, the unlawfulness of Advocate Chauke's conduct is all actions he took in the context of this matter, particularly relating to prosecutorial decisions as the de facto DPP in this matter. Those actions that he would have taken in that context would be unlawful. This particular act of finalizing an affidavit, generally, it would not be, in fact, DPPs would be involved in such actions for a national director to settle affidavits. But if in the settling of the affidavit, you are actually taking a prosecutorial decision to appeal a matter or to recommend to the NDPP that this matter be appealed on the basis of the contents, or not appealed, the matter be opposed on the basis of what is contained in the answering affidavit, then in my view, that amounts to his role as the de facto DPP and would in fact also be something that a decision a prosecutor would take in terms of opposing an application. And in that sense, it would be unlawful conduct.
It's kind of a long answer, but I just want to ascertain from you whether that single act in relation to 3.1.3 of the terms of reference specifically reflected as I quote, he finalized the answering affidavit of the then acting National Director of the Public Prosecutions, Advocate Nomgcobo Jiva, in the Boyson's review proceedings. It is that just to focus on, understand whether the allegation of unlawfulness in your affidavit at paragraph 142 covers that limited aspect of the terms of reference that I have just read to you. Let's not talk about anything else because I assume they will deal with further decision. I just want to clarify in my mind whether this act of settling an answering affidavit on behalf of the head of the NPA in itself constitute an unlawful action.
Chairperson, my answer to that is yes, it does. For the following reason, that a decision to oppose a review application is a prosecutorial decision. And that decision to oppose was taken by Advocate Chauke and supported by him as reflected in the contents of the affidavit that he settled.
And that affidavit that he settled is not his affidavit. It is under the signature of the head of the NPA.
That's correct.
Who will take the rap for whatever is in that affidavit, irrespective of who settled it?
That's correct.
Am I correct?
Well, that's correct. She will take the rap for it to the extent that, there's anything unlawful about that. If there is.
No. I just want to ascertain from you as to, even if somebody drafts something for you as the head of the NPA and you append your signature ultimately on that very document, it is you who's going to be accountable for whatever appears in the document that you sign.
Yes, Chairperson, to the extent with regard to the conduct of the signatory to an affidavit, you will be, but here we're looking at the conduct of Advocate Chauke before that in taking a prosecutorial decision.
I'm not asking about that, Counsel. I'm just talking about a simple thing in relation to signature and the impact of your signature on a document, irrespective of who drafted it, that you finally apply your mind to the content of the document and decide if you align yourself with its content. That's what I'm trying to ascertain with you. That finally, irrespective of who proposed, who advised, who drafted it, you are the final decision maker in relation to the content of this very document. That's what I'm just trying to ascertain.
That's correct, Chairperson.
Yes, thank you.
Thank you, Chair. Advocate Batoy, I am still on 3.1.1.4. And perhaps to close off on the discussion you've had with the Chair, I understood that you accepted that the entirety of 3.1.1 is about racketeering. And you also accepted that racketeering is within the exclusive power of the NDPP. Was I correct?
Sorry, what section? 3.1 point?
Point 1, all of those sub-paragraphs are about racketeering.
That's correct.
And racketeering is within the exclusive power of the NDPP.
That is correct.
Now, I'll go through now to 3.1.1.4, but just to close off on what the chair has asked you. There is no charge that I have seen here that accuses Advocate Chauke of acting outside of his jurisdiction, particularly on racketeering, which is the exclusive power of the NDPP.
I need to check this, Chairperson, if you give me a minute. Yes, there's nothing here that says he acted outside of his jurisdiction.
Thank you. Can we then move on to 3.1.1.4? And again, just to remind you, the exercise I'm doing now is to analyze the charge to ascertain precisely what is the scope. It says you instituted, I'm inserting you instituted, an appeal against the judgment of Judge Govan in the review case of Boysen versus acting NDPP without the approval of then National Director of Public Prosecutions, Mr. Mxolisi Nxasana, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused and no justification for lodging an appeal against the judgment. Now, you have not referred us to any record indicating the decision by Mr. Chauke to institute the appeal. And perhaps you can come back on that on Thursday when you go through the record.
I can try to deal with it now.
All right, carry on.
To the extent that I can. I certainly won't have time to look at the record between now and Thursday. The issue is that the matter of the appeal against the Govan judgment, certainly Mr. Nxasana, if he is called, will be able to give clarity on this. But my understanding is that I think Advocate Chauke's response to the president might help us in this regard. If I could just have a look at that. Do we have that letter? If you'll bear with me, Chairperson, I just think there's something about this in this letter. Here, paragraph 42 deals with his response to the president, Chairperson. If I could just read it, it might help me. Should I read it aloud, Chairperson, or just to myself?
You may, ma'am.
Thank you, Chairperson. Mr. President, following the judgment from the High Court, the prosecution team received a recommendation from Holders SC, who represented the NPA in the review application, that there were good prospects of success in the appeal. Advocate Holders expressed a concern that considering that the days for the lodgement of the application for leave to appeal were soon to expire, it would be advisable to provisionally lodge the application pending the final authorization from the NDPP, so as to avoid the compilation of having to seek condemnation if the NDPP were to decide to pursue the appeal, and that if the NDPP decided against the appeal, it would simply be withdrawn. I was present at the meeting at which this was discussed. My reading of this then would be that Advocate Chauke decided to, as it says, provisionally or advise or instruct, I should say, because it would be the instruction, Advocate Hodes would only act on the instruction of the NPA, to provisionally lodge the application pending authorization from the NDPP, which means that at that point, there was no authorization from the NDPP to do this. But Advocate Chauke indicates reasons why they needed to move quickly because of the DS. And so in my reading of that, it would be his instructing Advocate Hodes to institute the appeal. Yes, thank you, Chairperson. That's my response.
Well, I honestly do not understand what you have just said. My question is simple. You have not referred us to a single document in which it is recorded that it was Advocate Chauke's decision to institute an appeal. Paragraph 42 does not say that.
In my view, it does.
Show me the words there which says it was my decision to institute the appeal.
It's my reading of that section that my conclusion, well, my reading of this is that Advocate Chauke decided to advise Advocate Hodes to provisionally lodge the application, which in my view is instituting the appeal.
So,
but of course, he says pending the authorization of the NDPP.
So even though the paragraph does not say, I instructed the institution of the appeal, you decided to read it as meaning that that is what it says.
From the evidence, we know that the appeal was in fact lodged.
That is not the issue. The issue is whose decision was it? You have charged Mr. Chauke as the person who made the decision. I am looking to see the factual basis for the charge, which presumably you would have had even before Mr. Chauke made representations to the president.
The factual basis is that Advocate Chauke, as the de facto DPP in this matter, met with Advocate Hodes, and after that meeting, there was an appeal that was lodged. And in my reading of that, it was on his instructions, because if you read further, he then briefed on paragraph 40. Well, at paragraph 43, he says he briefed Dr. Ramaite on the recommendation we had received from council. He expected, I'm paraphrasing, Dr. Ramaite to brief the NDPP. That is my reading of the evidence.
Now, Advocate Patoy, please help us here. This paragraph 42 and 43 are things that happen way after you have recommended to the minister that Mr. Chauke must be charged for bringing the appeal. At that stage, when you took the decision, you must have had a factual basis. Point us to it.
It's in the evidence bundle. Dr. Broughton's affidavit and the evidence. My recollection in summary, as I mentioned, and I will mention again, is that Advocate Chauke, if I'm not mistaken, there was a prosecution memorandum that was drafted in support of the appeal. He met with Advocate Hodes, and thereafter there was an appeal that was lodged. without the NDPP's approval. In my understanding of that, Advocate Holders would have acted on the instructions of Advocate Chauke.
Yes. All right. So as matters stand, you are relying exclusively on the report of Dr. Broughton. You are not relying on any objective memorandum signed at the time to instruct the institution of the appeal.
Dr. Broughton's report has the evidence attached to it. So I am talking about his report, which has a comprehensive dossier of evidence, which is about a lever arch, maybe more than that. I think it's a lever arch and a half full of the evidence. So I looked at documents and the evidence and not just what Dr. Broughton said.
All right. So as I understand then, again, to try and define the scope of the charge, you are saying if we read the report of Dr. Broughton, we will find there a document prepared by Advocate Chauke which instructs the lodgement of the leave to appeal.
It's not what I said.
Well, I thought that's what we've been discussing for the last 5 minutes.
We have been.
So then, when I asked you to exclude the report to the minister, because it came after your decision, and you said, well, look at Dr. Broughton, and I'm now asking you whether it is your evidence that Dr. Broughton has attached to his report documentary proof of an instruction from Mr. Chauke. Are we going to find it or not? Very simple.
You will not find a document of that nature.
Yes, all right. Thank you very much. Now, I just want to go to the analysis of 3.1.1.5. It is alleged in this charge that you, Mr. Chauke, attempted to have racketeering charges against Major General Boyson and members of the Cato Manor unit reinstated by the then National Director of Public Prosecutions, Mr. Nxasan, notwithstanding that there was no evidence justifying the institution of racketeering against the accused. Now, I have 3 questions. The first is whether or not this charge is limited to racketeering or includes the independent subsidiary offenses.
It's limited to racketeering, in my understanding.
Thank you. The second is whether or not this charge suggests that there was no case of racketeering for everyone, not just Major General Boyson.
It does. Well, let me read that quickly before I respond so fast. It does.
Yes. The third one is, on what basis do you say it was Advocate Chauke who attempted to have the charges reinstated? Just show me the document where he tried to do that.
I'm trying to recall the evidence of what Advocate Chauke did after Advocate Nxasana was appointed. And I can't recall it at the moment, what exactly the evidence is in that regard.
You can't recall.
I can't recall what the evidence is in this regard.
Yes, I understand. But it's unfair to ask you to recall all of the evidence.
Thank you very
But
much. I appreciate that.
I can ask you to recall at least one thing, which is, on what basis did you suggest that it was Advocate Chauke who attempted to reinstate the charges? Surely you must recall that.
I can't recall what his conduct was at that point regarding what happened when, but for the appeal aspect, I'm not sure what more Advocate Chauke did. What I do know is Mr. Ngasana at some point asked Advocate Chauke, after he raised the issue of him exercising, I'm not sure how it was exactly put, but the fact that Advocate Chauke had no jurisdiction in KZN, and he then said that this matter must be dealt with by Advocate Noko. That's what I recall. So I can't, besides that, I don't know what exactly he would have done to have these charges reinstated after Mr. Ngasana was appointed.
Yes. Because it seems
If there's
to me,
any evidence, it will speak for itself. As I said, I'm testifying about things that happened when I was not even there. So it's about the evidence that should speak and not my trying to recall what the evidence was. That's what the idea of this fact-finding is.
you see, Advocate Batoy, it seems there are two independent acts that are being conflated. The first one is whether there was ever any attempt to bring life to these charges under Advocate Ngasana. The second is whether Advocate Chauke was involved at all.
Mm-hmm.
As I understand, you can't help us on either.
I can't, but hopefully the evidence leader can look into this, and if there's any evidence that needs to be led, any facts that needs to be brought to the attention of this panel, it will be done. If there isn't anything, that's the position.
Can you recall when Advocate Ngasana assumed the office of NDPP?
No.
If you go to LO 00886,
Advocate Nkosi.
thank you, Madam Chair.
Please repeat that.
LO 00886.
Mm-hmm.
There is an email of the 11th of April 2014 at 2:51 p.m.
Mm-hmm.
from Mr. Chauke to Dr. Ramaite. Can you see it?
See one at 3:20 to
Yes,
51.
there is one below that.
To Dr. Ramaite.
Yes.
Mm-hmm. Yes, I see that, 251.
Mr. Chauke says, I refer you to the comments and reservations of both the NDPP and yourself regarding my involvement in the Cato Manor matter. I refer also to a subsequent meeting that I held with the NDPP on 8 April 2014. I hereby confirm that I will no longer take part in any way regarding the management and prosecution of this matter. I have accordingly informed the team leader, Advocate Mayema, and the DPP KZN Advocate Noko. That is dated the 11th of April 2014, referencing a meeting with Advocate Ngasana on the 8th of April 2014, where Mr. Chauke says he will no longer participate in any manner whatsoever on Cato Manor. So surely your evidence on 3.1.1.5 must show us that after this date, Advocate Chauke attempted to have the racketeering charges reinstated.
As I said, I'm not the only witness in this matter. I don't know what the evidence is going to show.
Well,
Please, repeat the question, and if you can just try maybe to confine yourself to the question that has been asked. If you know, yes. If you don't know, no. So that we obviously know your stance about this question.
Yes.
Because I'm not sure how you are answering it, Advocate Batoi. Please repeat the question.
Thank you, Madam Chair. Advocate Batoi, I referred you to the email of the 11th of April 2014 at 2:51 p.m. written by Advocate Chauke to Dr. Ramaite, in which Advocate Chauke says, bearing in mind the discomfort of the NDPP, which was expressed in the meeting of the 8th of April 2014, he withdrew from involvement in any manner on the Cato Mano case. Now the question is, surely to establish 3.1.1.5, you would need to produce evidence that after the date of the 8th of April 2014, Advocate Chauke attempted to have the charges reinstated.
My response to that is I don't need to produce the evidence leader needs to. I will testify about what I know, what evidence there is. I don't know what happened after that.
All right, let me not say you need to. Let me ask you, do you have the evidence?
As I sit here, I don't have any evidence.
All right, thank you very much. Could I then try and do an analysis of the following charge?
Just for clarity, and it is the evidence in relation to the alleged attempt to reinstitute
Yes, Madam Chair.
the
Correct.
racketeering charges.
Yes, correct. Now, could I also just try to analyze 3.1.2? That is the Mr. Mdluli charge. Now, could I just understand the scope of this charge again? Now, I'm going to reference a discussion that you had with panel member Ramaphosa. When she asked you about the charge, particularly with the use of the word "in that" as suggesting a limitation of the scope of the charge, you said in your response, maybe these terms of reference must be amended. Can you explain why you said that?
I can't remember the context of that particular question.
You can't remember.
Let me read this and see try to gauge what I might have meant by that. To the extent that this is not complete in terms of the conduct of Advocate Chauke's that we complain of, I would have possibly meant that it should be amended to include his conduct not just at the point of withdrawal of the charges initially and submitting it to an inquest, but also his conduct after that, after the inquest hearings, not hearings, yeah, they were hearings, after the inquest process was completed, his conduct in then not in accepting, well, not accepting, his conduct in coming to a conclusion that the magistrate found no evidence implicating General Mdluli when that was incorrect. The magistrate's findings were confusing and contradictory. So in that regard, Advocate Chauke at that point ought to have reconsidered the matter given two things. One is that the prosecution team said there was strong evidence against General Mdluli, the fact that the magistrate's findings were confusing, and also the fact that the representations of General Mdluli was a fanciful conspiracy. So that's the next point of decision making. Thereafter, Advocate Chauke's conduct after the the Murphy judgment, when Judge Murphy was very critical of the conduct of Advocate Chauke, and
And I just want to put a proposition to you for your comment. As you know, because Mr. Chauke has made representations, he says he was uncertain about the strength of the evidence. Is it your case that a prosecutor does not need to be certain about the strength of the evidence?
that's not my case. That's what Advocate Chauke says.
No, I understand that his justification is that he was uncertain. I'm asking you why he is being charged. Is he being charged because you are saying a prosecutor does not need to be certain about the evidence before they enroll a matter.
That is not the reason why he's being charged.
But what is your answer to my question? Are you saying that the prosecutor does or does not need to be certain about the evidence before they put the matter for a charge?
A prosecutor must be certain of the evidence.
Yes. Now,
Perhaps, Counsel Advocate Batoy, are you suggesting, as regards the evidence that is to be presented at the trial, at the state of charging, a prosecutor must be certain of all the evidence that needs to be presented to prove the charge? Is my understanding correct? Or should there be merely a prima facie evidence to institute that charge? If you can clarify that to me, or clarify your answer to Advocate Nkweto.
Person, yes, thank you for that question. I'm not suggesting that at the point, because at that point could in fact be prima facie evidence. It could be a situation where a person has been charged because there's sufficient evidence to charge, but at that point you should be certain of that level, whether it's prima facie. You must be certain that you have sufficient basis to charge the accused at that point. It doesn't mean that it will be all the evidence, because investigations could continue and more evidence could be gathered. So, but I think the question that I was answering to Advocate Nkaitobi was slightly different. My understanding of his question is that if a prosecutor, well, put conversely, is uncertain of the evidence, should you charge? And my answer to that was no, you should not.
Thank you.
thank you. Well, it seems you've given inconsistent answers to my question and the chairperson's question, which are effectively the same question. Maybe let me give you a chance to clarify. What should a prosecutor be certain about? What is he allowed to be uncertain about before he makes a decision to charge?
Well, firstly, let me say I have not given inconsistent answers. I've answered different questions. And to your question, and the record will show, we can go back. Your question was, put conversely, whether a prosecutor should enroll a case if he is not certain of the evidence. And I said, no, that should not be the case. The chairperson's question went further and asked whether at the stage of charging, a prosecutor must be certain of all the evidence, and whether shouldn't there be a prima facie evidence. And my answer to that was that when a prosecutor charges, they need to be certain that at that point, it meets the standard that is required for the enrollment of a matter. That could be either at the level of prima facie evidence, which is completely in order for you to enroll it, but that doesn't mean you are certain of all the evidence, because there could be evidence that is obtained after that. So I hope I'm clarifying. In my view, I'm not giving inconsistent answers because the questions were slightly different.
Yes, thank you very much. Now, could I also ask you about the issues in relation to the Mr. Mdluli matter? Is it correct that you relied exclusively on the memorandum by Advocate Gathali SC?
That's not correct.
What else did you rely on?
prior to me asking for his opinion, I had received the opinion of Advocate Nalane, who recommended that this be one of the matters that be included in any referral to the president. I had Advocate Chauke's response to that in his in the form of Advocate Maineche's opinion. I think I must just look at my letter that I sent to Advocate Chauke before I respond further, to make sure that I am clear that my recollection of what happened a couple of years ago is correct. The letter to, is it in here? Okay. Might be an attachment to my affidavit, Chairperson.
Is it when you requested Advocate Chauke to present further information?
On the 5 matters.
I beg your pardon, may I finish?
My apologies.
In a document attached to your affidavit, SB6 at 240, and I'm not sure whether this is a document where you requested for further information relating to the decision made by you as the DPP Gauteng Johannesburg, and Advocate Chauke then responded from SB 6241. Is that a document?
Yes, I think it's SB5, Chairperson. Just check that now.
You see, the one that I'm referring you to, just let's deal with the one that I'm referring you to first. That one is SB 6241, attached to your affidavit. Those additional documents that you filed of record, and in the first heading, he deals with the Richard Mdluli murder case and the related charges. Is that the document you wish to refer to?
No, Chairperson.
Okay, let's look at SB 5 that you referred us to then. Only SB 5 that I have here is your request to Advocate Chauke, SB 5231,
That's correct.
which then culminated in his response at SB 6.
That's correct.
The SB 5, is that the one that you're looking at, your request to him?
That's correct.
Yes.
I'm looking at paragraph 2 on page 232. So I had access to documentation in a file. I had a 2.2, there was a decision, a court decision. In fact, there would have been all the decisions. It would have been the Judge Murphy decision as well as the SCA Brandt decision, as I set out. So I would have had also Advocate Chauke's response to this matter in SB 6. I think that's all the information I would have had. That's the information I would have had before the opinion from Advocate Hully.
Yeah, we noticed that it's now past 12 o'clock.
Going to
Okay.
It's 12:03.
Yeah, it's past 12 o'clock. Okay.
Thank you for reminding us, because I cannot be late for my appointment.
I had actually thought that maybe I should find out, Council, whether you are ending it up at General Mdluli's point, the terms of reference 3.2, or you want to exhaust this question before we step out?
Chairperson, may I please comment on that? Well, let's hear what Advocate Mugaitobi says first.
That's fair, because I'm asking him the question, not yourself. Shouldn't you wrap up, or you want to tie it up?
Madam Chair, I can stop now, but it's not a convenient place, but the agreement was that we would cut off at 12, so I should stick to that.
Advocate Batoi, as Council mentions, it may not be a very convenient point to leave the questions hanging, but given your request, we will, I see you anticipate what I'm going to say. We'll definitely adjourn, because we bear in mind your earlier request that you be afforded an opportunity to go and attend to your personal matter.
Thank you, Chairperson.
So you need not change your face, because
Thank you, Chairperson. I'm only human.
we are going to adjourn to keep our undertaking to enable you, as per your request, to adjourn now until Thursday morning. To all concerned, Council, Advocate Batoi, we will adjourn and reconvene on Thursday morning, the 11th at 9 o'clock. In the meantime, we will request that we be finished with the document that was to be provided earlier, so that when we reconvene, we would have had a look at it. Please instruct your team to file that document or give us copies.
Thank you. I'm indebted to the panel.
We will adjourn until the 11th of December, Thursday at 9 o'clock.
Congress. We received only 40% of the national vote. This was the first time since the advent of democracy that our share of the vote was less than 50%. While the ANC remains the most supported party, with almost twice as many votes as the next party, we suffered our greatest drop in support since 1994. We lost our majority nationally and in key provinces of Gauteng and KwaZulu-Natal. Among other things, the drop in support can be linked to the emergence of the MK party, the dissatisfaction of our people with unemployment and lackluster economic growth, service delivery challenges, and anger and perceptions of widespread corruption, but also the weaknesses in our own structures, which we clearly saw with a weak election campaign that could have been a lot better had our structures been stronger. The record low voter turnout of 58% affected the ANC more than other parties. The NEC agreed that the election results placed a responsibility on the ANC to give leadership to the country and ensure unity, stability, peace, and progress in the nation. After considering various available options, the NEC decided that we should invite all political parties in the National Assembly to form a government of national unity as the best approach to move the country forward. Following engagements, a government of national unity was established with 10 parties participating: the African National Congress, the DA, the IFP, the PA, FF+, the UDM, Rise Mzansi, Al-Jamaa, the PAC, and the Good Party. The parties agreed on a statement of intent committing to respect the Constitution of our country, the rule of law, and to promote accountability, transparency, integrity, and good governance. They agreed on a basic minimum program, which formed the basis for the medium-term development plan. The GNU identified 3 priorities. Firstly, to drive inclusive growth and job creation. Secondly, to reduce poverty and tackle the high cost of living. And thirdly, to build a capable, ethical, and developmental state. In its assessment of the first year of the GNU, the NEC agreed that we have safeguarded the core progressive policy agenda of the National Democratic Revolution. Through the GNU, the ANC has continued to execute its agenda for nation building and fundamental social and economic transformation, albeit under difficult conditions. We have stood firm against resistance campaigns mounted by right-wing forces and have not retreated from progressive domestic and foreign policy positions. The 55th Conference agreed that building an ethical and capable state is essential for economic transformation. A fundamental feature of such a state is a public service that is professional and competent. To this end, the National Framework for Professionalization of the Public Service was adopted by Cabinet in 2022. Recruitment and selection processes are being overhauled, along with performance management systems, competency-based assessments, and integrity tests are also being introduced, particularly tests that will be able to give us information about the integrity of those who should serve our people. One of the other key aspirations of the professionalization framework is the depoliticization of the public service. Those who work in all spheres of the state need to be insulated from undue political interference and vested interests as well. State capture provided a bitter lesson on the vulnerabilities of the public sector to interference by private business interests. Our conference resolved to strengthen local government by addressing political and administrative instability, improving service delivery, and strengthening accountability and financial sustainability as well. Many cities and towns across our country are failing to deliver basic services, creating serious challenges for the residents, for businesses, and for public facilities such as schools, clinics, and hospitals due to the lack of proper basic services delivery. Government has therefore initiated comprehensive reform of the local government system, including the review of the White Paper on Local Government and Local Government Fiscal Framework. The Presidency is providing targeted intervention and support in struggling municipalities, starting with eThekwini and Johannesburg. Working groups in both these metro cities have brought together mayors, senior government officials from all government spheres, business, and civil society to tackle urgent problems. The district development model continues to enhance efficiency by having the three spheres of government, including other key stakeholders, aligning planning, budgeting, and implementation to reduce fragmentation, duplication, and wastage. We are committed to continue working with our traditional leaders to ensure that they can play their essential role in promoting sustainable and inclusive economic development while being custodians of heritage, culture, and traditional values. To address widespread misconduct and corruption, the public procurement system needs substantive reform. The Auditor General reports that much of the corruption that they unravel in their reports is embedded in our procurement system. National Treasury is preparing for implementation of the Public Procurement Act, which will introduce a new framework and establish a public procurement office. We need to ensure that procurement is used as an instrument to build Black and women-owned companies that produce the products and provide services that government needs. It is found that too many tenders that are issued to middlemen or middlewomen who do not have the relevant competence to provide services and products as well. This is a waste of public funds. It encourages corruption and does not advance real economic empowerment. One practice that has weakened the state is the practice of outsourcing functions that should be performed by government departments and public bodies. The effect of this is that public institutions no longer have the skills and the capabilities that they need because they outsource many of the functions that should be performed and conducted by a capable state. We need to get rid of outsourcing of simple and straightforward functions in our government system. Outsourcing opens the door to corruption, with many cases of tender manipulation, bribery, overpricing, and the use of front companies. But it also makes those who work for those entities that we outsource to be vulnerable, because their job situation is always tied to the tenders that those companies or entities receive. Once the tender comes to an end, they become unemployed. We therefore need to give dignity to our people by making sure that they gather good skills and they have permanence in their employment through our work in the public sector. The ANC should act to end the practice of outsourcing core functions of the state. The capacity of the state to perform these functions needs to be rebuilt. The 55th conference observed that South Africa needs rapid, inclusive growth to create jobs. After more than 15 years of low economic growth, we are now beginning to see the signs of a turning point. Much as some, even within our ranks, say this is a delusion, it isn't a delusion. The most recent projections from the National Treasury show that we can achieve much higher growth over the next 5 years if we implement our policy commitments. Our experience shows that when our economy grows, jobs are also created. In the first 15 years of democracy, when our economy grew at above 3% a year, employment rose and poverty fell. In the second 15 years, when growth fell to 1%, unemployment and poverty rose. We have therefore undertaken a strategy to achieve higher levels of inclusive growth through accelerated infrastructure investment, forward-looking industrial policies, improved service delivery, land redistribution, transformative spatial planning, Black economic empowerment, and supportive macroeconomic policies. As the ANC, we have been clear that growth must be inclusive. It must drive radical social and economic transformation through redistribution of wealth and opportunity. It must support empowerment of Black South Africans and women. In the face of a concerted campaign to push back broad-based Black economic empowerment, the ANC has remained steadfast in defense of the constitutional imperative to redress the imbalances of the past and to pass legislation that will redress those imbalances, thus enhancing the empowerment of our people as a whole. One of the most pressing challenges that we face in our country is youth unemployment. Approximately 3.5 million out of the 10 million people, young people aged 15 and 24 are not in employment, in education or training. Since October 2020, the Presidential Youth Employment Intervention and the Presidential Employment Stimulus have created earning opportunities for more than 2 million participants. The Basic Education Employment Initiative has brought young teacher assistants into almost 25,000 of our schools and been able to create 1 million job opportunities for young people as school assistants. This has been a phenomenal program that has covered the schools of our country right across. The SA Youth Mobi platform that was launched in 2020 now has over 5 million registered young people. The platform is an online network that connects unemployed young people with jobs, with learnership and training by matching them with local opportunities and support. 70% of opportunities on the platform have been accessed by young Black African women. Around 65% live in households where at least one member receives a social grant. The Youth Employment Service, a joint initiative of government and business, has provided 200,000 young people with year-long work experience opportunities, making it the largest corporate-funded youth jobs program in the world. The 55th conference reaffirmed that industrial policy must be a leading instrument of economic development and transformation. South African manufacturing is under pressure at the moment from rising electricity prices and logistical challenges. For industrial policy to succeed, it must be forward-looking, positioning diverse industries to succeed in an increasingly digitized and decarbonized world economy. We need to be bold in developing new industries like battery storage, renewable energy components, and electric vehicle production. South Africa has among the best solar and wind resources in the world, with the Northern Cape being said to have the best radiation of all countries in the world. Yes, it does, including Comrade Zamani, having a town which is called Hotazel, meaning that it is as hot as hell in Hotazel. But what is pleasing with this is that we are utilizing this natural resource to attract investments. The Northern Cape has seen the most investments in renewable energy, utilizing the sun or solar, and the Eastern Cape has also seen great and increasing investments in wind power, as the Western Cape, and now Mpumalanga and Limpopo are also going to see heightened investments in utilizing our natural resources, including methane gas, which has been found in Mpumalanga. Well over 100 billion rand has been invested in renewable energy projects in the Northern Cape. And Comrade Zamani reports that we have seen great growth in the Northern Cape. Industrial expansion requires efficient, reliable, and competitive network industries. However, over the course of more than a decade, our state-owned enterprises in these network industries, particularly Eskom, Transnet, and PRASA, declined due to the effects of state capture, mismanagement, and a lack of capital investment. To correct this, and in line with the resolutions of the 55th National Conference, government is leading a process of structural transformation in energy, in water, in our ports, in our rail and telecommunications. Now, through this work, we are reducing costs, we are improving efficiency, we are lowering barriers to entry, and enabling higher levels of investment. we have seen a dramatic drop in load shedding frequency and severity. This has been made possible by steady improvement in Eskom's performance and regulatory changes to allow private investment in electricity generation. And we have to applaud those who have been working on these programs of ensuring that load shedding is something of the past. We have to applaud them. Government recently finalized the Integrated Resource Plan 2025, outlining a balanced and diversified energy mix. Renewable energy capacity will increase from 17 gigawatts to over 45 gigawatts by 2030, continuing to grow to provide more than half our energy supply. The country is moving towards a competitive electricity market. While Eskom will continue to play a leading role, the new model will enable many generators to supply electricity and compete based on efficiency and costs, and leading to lower prices and more reliable supply. And this is necessary so that we see more investors coming in, alleviating the burden that our state-owned enterprise Eskom should carry on its own as we increase energy generation. We are making significant headway in increasing the volume of goods that are moved on rail lines and through ports. After dramatic decline, freight volume increased from 150 million tons in 2023 to 174 million tons in 2025. We still need to increase the volume of goods that are transported on our rail to well over 250 million tons. Transnet has established a rail infrastructure manager and made capacity available to train operating companies on a concessionary basis, whilst the rail infrastructure itself continues to be owned by the government. PRASA has restored 35 of 40 priority lines, meaning that commuters can now travel safely and affordably on locally manufactured trains. In the last financial year, PRASA recorded 77 million passenger trips on its lines, a huge increase from 39 million in the previous year. So things are moving and people are being moved on our trains. The 55th National Conference noted that expanded infrastructure investment can play a critical role in providing basic services and improving economic performance and job creation. However, over the past 15 years, investment by both the public and private sector has declined. The ANC-led government has made a commitment to invest more than 1 trillion rand in infrastructure over the next 3 years to renew our roads, our ports, our rail, our energy and water systems. This is the largest amount ever budgeted for infrastructure development in the history of our democracy. This will increase our gross fixed capital investment, which has been in decline over a number of years. Government has also allocated an additional 54 billion rand to fix water and electricity infrastructure in the 8 metros linked to institutional and financial challenges. We must use our infrastructure build to maintain maintenance programs, to create platforms for black industrialists, for workers, for small businesses and marginalized communities in urban and rural areas. We must ensure that it assists us in localizing production of critical inputs such as steel and promotes processing and beneficiation of our rich mineral endowment. Disruptions to the global trading system are threatening South African exports. Like most other countries, South Africa had punitive unilateral tariffs imposed on it by the United States of America earlier this year. Our government is continuing to engage the United States in negotiations to reach a trade agreement that benefits both countries. At the same time, we have had to accelerate the diversification of our export markets. South Africa continues to play a leading role in supporting the implementation of the African Continental Free Trade Area to grow South Africa's exports to the rest of the continent. We've had thoroughgoing discussions with a number of companies that do business in the rest of our continent, and our cooperation with them will be enhanced. While we strengthen the resilience of our export industries, we need to continue to advocate for an international trade regime that is fair, equitable, and rules-based. Land reform remains one of the most urgent tasks of the National Democratic Revolution. Some economists estimate that almost 25% of all land previously owned by white landowners has been restored, redistributed, and moved to state ownership. But there is still a greater hunger for land, and much work still needs to be done to give effect to the constitutional requirement that all citizens must be able to gain access to land on an equitable basis. Key tasks ahead include the improvement of support systems for beneficiaries of our land reform program. We need to accelerate the processing of outstanding restitution claims and resolve disputes more efficiently. Equally important is addressing urban land reform, as most South Africans now live in cities where access to well-located land and housing remains deeply unequal. As directed by the 55th Conference, the ANC-led government has continued to maintain macroeconomic stability and coordinate fiscal and monetary policy to support inclusive growth. Sound management of public finances is essential. A critical challenge in recent years has been the rising public debt, with more than 20% of tax revenues spent on debt servicing payments. Important progress is underway in reducing corruption, wasteful spending. However, cutting spending across the board carries significant social and economic costs. Instead, we need to reduce spending on inefficient programs and increase spending on programs with the greatest impact amongst our people, such as infrastructure investment, while maintaining social assistance to poor and working-class households. The measures that we are taking to strengthen public finances is creating a shift in public sentiment and investment. Over recent weeks, our sovereign credit rating has been upgraded. We have been removed from the FATF grey list. Interest rates on government bonds have decreased, and our currency has also strengthened. In the last few days, the National Treasury's latest bond issue was oversubscribed almost 4 times and was issued at much lower rates than before, reflecting renewed confidence in our economy. Some leading business people have said that due to the measures that we are taking, the South African economy has turned the corner after more than a decade of decline due to state capture, the COVID pandemic, the 2021 civil unrest, and the devastating floods of 2022, and weaknesses in government execution. Next year, the country will celebrate 70 years since the Women's March on the Union Buildings on the 9th of August, 1956. We will recall the courage as well as the determination of the women of our country in standing up not only to the apartheid government, but to laws, practices, and attitudes that prevented South African women from realizing their rights. We are fortunate today to have Comrade Sophie de Bruyn amongst us, who is a Isitwalandwe, who participated in that march. As the ANC, we have carried that spirit into our democratic constitution, into our laws, policies, and programs. This year, the world marked the 30th anniversary of the Beijing Platform for Action on Women's Rights and Gender Equality. This landmark development has had a profound impact on our own country's efforts to advance the position of women in society. Today, South Africa ranks second. I repeat this. South Africa ranks second out of G20 countries in terms of women representation in parliament. Over a quarter of top managers in the private sector are now women, and just under half of senior managers in national government departments are women. Comrade Sisisi Tolashe, I have to apologize that you found so many men standing here during our candle lighting, and we hope that too will change, as you are indicating with your hands. As we all know, we have made tremendous progress since our 48th conference that was held in 1991 with regard to the empowerment of women as the African National Congress. Government has made, and I think we should applaud the ANC Women's League for continuing to champion the cause of women in our organization. Government has made a commitment to 40% preferential procurement in favor of women-owned and women-led companies. At present, only 16% of government procurement spend goes to women-owned companies, while a further 25% goes to companies that are partially women-owned. We will increase this. This demonstrates clear progress in advancing the position of women in the economy of our country and in public life since the advent of democracy. However, it also shows that we have much further to go until we acquire and achieve gender equality. We are at the midpoint of implementing the National Strategic Plan on Gender-Based Violence and Femicide. Yet violence against women and children continues unabated. While we can point to progress In responding to instances of gender-based violence, our greatest challenge is prevention. On the 20th of November this year, government classified gender-based violence and femicide as a national disaster. This classification will support implementation of the National Strategic Plan through stronger governance, funding, communication, and coordination. Our efforts to prevent gender-based violence need to be intensified massively. It also needs to be scaled up and include all sectors of society. And in this regard as well, I would like to applaud the ANC Women's League for the leadership of our country in gender-based violence prevention. Comrades, crime and violence continues to take a toll on our society. Apart from the human cost, crime impedes social development and inclusive economic growth. Police continue working with our other law enforcement agencies to dismantle organized crime syndicates and combat financial and violent crimes. Initiatives such as Operation Chanela have had great success in arresting suspects, recovering firearms, seizing stolen vehicles. The South African Police Service has increased its intake of new personnel, including into units like public order policing and detective services. While the country has recorded a decline in some crime categories, we have seen a rise in extortion, kidnapping, and illegal mining. In response, the establishment of a multidisciplinary economic infrastructure task team in 20 hotspots has led to several breakthroughs. Involvement and mobilization of communities is critical to the fight against crime. Significant effort and resources have been directed towards reviving community policing forums. ANC branches must be integrally involved in strengthening CPFs and mobilizing communities in crime-fighting campaigns. As we work to rebuild our criminal justice system, we need to act when reports emerge and allegations are made that threaten and undermine the stability and effectiveness of these institutions. In August this year, we established a commission of inquiry headed by Justice Madlanga to investigate allegations about collusion of police and political figures in criminal activity. At the same time, our National Assembly established an ad hoc committee to probe the same allegations. This is necessary to establish the facts through an independent, credible, and thoroughgoing process so that we can ensure that accountability of our institutions and safeguard public confidence in the police service. We are hopeful that the findings and recommendations from these investigations will represent a turning point in our fight against crime and corruption. The integrity and the credibility of our criminal justice system is vital to ongoing efforts to combat crime and corruption. Over the last few years, we've made significant progress in building and strengthening law enforcement agencies, security services, and prosecutorial bodies. In the 3 years since the final report of the State Capture Commission was presented to the President, government has undertaken major reforms based on its recommendations. These include a raft of new laws to strengthen our anti-corruption institutions, to enhance the procurement system, reform the intelligence services, and improve corporate accountability and public administration. The value of assets linked to state capture recovered by the state is now over 16.4 billion rand. These are monies that were misappropriated that have been returned to the state. In 2024, we established the Independent Directorate Against Corruption in the NPA. In August, the National Anti-Corruption Advisory Council handed over its final report recommending the establishment of a permanent, independent, and overarching entity to deal with corruption. One of the most significant recent developments was our country's exit from the Financial Action Task Team grey list. This is good for the integrity and reputation of our financial system and a boost to South Africa's international reputation. Our 55th conference reaffirmed that Africa and its development remain the central objective of the ANC's international perspective and policy. While Africa has some of the fastest growing economies, overall growth is constrained by poor infrastructure, low investment levels, and instability due to conflicts. Many countries are constrained by a substantial debt burden, often spending more on debt interest payments than on education, health, and infrastructure. To accelerate sustainable social development, our continent needs to focus on growing investment and trade, building infrastructure, achieving debt sustainability, and promoting peace and stability. The African Continental Free Trade Area, which entered its operational phase in 2024, presents an unprecedented opportunity for African growth and development. Intra-Africa trade only accounts for about 16% of total trade on the continent. Therefore, increasing trade between African countries through the African Continental Free Trade Area will spur industrialization, attract investment, and encourage development of regional value chains. South Africa is well positioned to benefit from access to a single African market of over 1.4 billion people. With an advanced and diversified economy, developed infrastructure, and mature capital markets, South Africa is an attractive place for companies to locate their African operations. Meaningful social development and economic growth cannot be achieved until we silence the guns on our continent. Despite progress over 3 decades, recent years have seen reversal. There's been a surge of military coups in a number of countries on our continent, in countries such as Mali, Guinea, Sudan, Chad, Burkina Faso, Niger, Gabon, and Madagascar. We have seen devastating conflict in the Sudan, the Eastern Democratic Republic of the Congo, Tigray, and South Sudan. These conflicts have caused thousands of civilian deaths and displaced millions. Many parts of the Sahel region and northern Mozambique have suffered from terrorist attacks and insurgencies. And in line with the international stance of the ANC since 1994, our country has contributed to a number of UN, AU, and SADC peace operations. We have been part of fostering peace in Lesotho, Burundi, South Sudan and hosted negotiations that brokered ceasefire between the government of Ethiopia and the Tigray People's Liberation Movement. We must be concerned that the struggle of the people of Western Sahara for self-determination has been set back by the recent UN Security Council resolution, which strongly endorsed Morocco's autonomy plan as the most feasible solution, shifting away from past UN positions on a referendum on self-determination. This development calls for the intensification of diplomatic efforts to find a path forward that prioritizes the rights and the interests of the people of Western Sahara. The world faces severe interconnected challenges. Climate change crisis is worsening, with billions affected by underdevelopment, inequality, poverty, hunger, and unemployment. Economic growth remains subdued globally, with many nations burdened by unsustainable debt levels. The global balance of forces is shifting in different and sometimes contradictory ways. The economic and political rise of the global South countries is upending long-established power relations, and these changes are occurring amidst unpredictable and disruptive actions of a new U.S. administration, creating uncertainty and volatility. As a movement and as South Africa, our engagement in international relations aims to promote our country's national interests and protect our sovereignty and constitutional order. It is aimed at improving the well-being, safety, and prosperity of our people. Through the G20, the BRICS, and non-aligned movement, various UN platforms, our country is making an important contribution towards an international order that is more inclusive, that is more just, stable, and peaceful. As a country, we used our G20 presidency to promote practical actions to advance the interests of our continent and the global South. Through more than 130 meetings, we engaged on a bold, transformative G20 agenda that resets relations between countries of the North and South, which strengthens multilateral institutions and the rule of law. All key agreements at the G20 Leaders Summit are important for the well-being and development of the people of our country and our continent and the world. From actions agreed on debt sustainability to just transition finance, from critical minerals to international finance architecture, the G20 outcomes provide important support for our efforts to grow and transform our economy and create jobs. I have, in a national address, thanked the people of South Africa for the manner in which all of us were able to have a very successful G20. I now thank you as members of the ANC. I particularly want to thank our government officials, our ministers, but also more particularly those who were at the center of hosting the G20, which was our Minister of International Relations and Cooperation and our Minister of Finance. But I also want to applaud our comrades in Johannesburg for making sure that they embarked on a thoroughgoing process of cleaning up the city. Comrade Dada Morero, who I continue to phone every day, was able to assure me that we will have a successful G20. So I say thank you to Johannesburg as well. Well done. South Africa continues, comrades, to play an important role in promoting peace on our continent and far afield. And in this regard, the atrocities committed by Israel against the people of Gaza prompted our government to argue before the International Court of Justice that the State of Israel was in violation of the obligations under the Genocide Convention. Since the onslaught began in October 2023, more than 70,000 people are known to have been killed in Gaza, most of whom are women and children. South Africa welcomed the agreement on a ceasefire that resulted in the return of hostages and the release of many Palestinian political prisoners. However, it is a matter of grave concern that Israel is breaking the ceasefire almost on a daily basis. Our country continues to call for an immediate end to the assault on Gaza and its people, and for meaningful negotiations to commence towards the establishment of a sovereign Palestinian state existing in peace alongside the State of Israel. Anything short of self-determination and the recognition of the fundamental human rights of the Palestinian people will not be acceptable and will not bring peace to that region. We must be deeply concerned about the horrific suffering caused by the civil war in the Sudan, in which more than 150,000 people are reported to have died. South Africa continues to participate in different peace processes seeking to bring about a just and lasting peace in Ukraine. This includes our involvement in the African Peace Initiative, in which several African leaders visited Ukraine and Russia. Our efforts are informed by commitment to peaceful resolution to various conflicts. All conflicts reveal shortcomings in international mechanisms to maintain peace and security. The UN Security Council, in particular, has shown that it is incapable in its current form of fulfilling its mandate. There is therefore an urgent need for the reform of the UN Security Council and other international institutions to ensure that they are representative. This is in line with the decisions adopted by the African National Congress at its various conferences. Our reflection on the work of the Renewal Commission, which was decided on by our conference. The ANC's program of organizational renewal is showing progress. The SG will report on this in the medium-term report that he will present shortly. There is still important work to be done, and the movement must continue to attend to both organizational and ideological renewal. And unless the ANC succeeds in renewing itself, we will perish. We must build better and activist branches. We must revive sectorial work. We must strengthen the alliance. We must reassert ANC values and principles and strengthen organizational integrity. The ANC appointed the first Renewal Commission during 2017 and 2022 term, with the main brief to develop an ANC Vision 2032. The discussion document on the vision was completed and presented to the NEC and the National Conference in 2022. Vision 2032 will be made available to NGC delegates to consider as part of their commission deliberations. The second Renewal Commission highlights the need to continue strengthening the key elements as parts of renewal. And these include organizational design, cadre development, integrity, and revolutionary morality. As we proceed towards the 120th anniversary of the ANC, the Renewal Commission recommends specific areas for attention and focus. Firstly, to eradicate factionalism and patronage by intensifying efforts to build unity in our ranks. Secondly, to reassert political discipline and cadre accountability by becoming more systematic and vigorous in ensuring accountability. Thirdly, to modernize and streamline organizational processes to make them more efficient and accessible. And fourthly, to strengthen ideological training and leadership skills by intensifying political education, which is currently underway. Fifthly, to diversify and broaden the demographic composition of our leadership structures. And lastly, to enhance the integrity and candidate lists by strengthening transparency in candidate selection processes. We also need to reinvigorate the alliance by creating and strengthening alliance forums for discussing ideology and strategy. We must also undertake grassroots mobilization through regular engagement with the masses of our people through door-to-door engagement, imbizos, and other forms of mass work. Now, I want to stress that in the last election, comrades, if we are to be honest with each other, our door-to-door culture was not at its best. We did not do vigorous door-to-door. And as a result, on election day, that's why we saw so many people staying away from the polls. And in part, it was largely because they had never been touched by the ANC visiting their homes, visiting the various locales that they go to. We must therefore, as we approach the next local government elections, ensure that we go back to basics. We go back to what has made us a strong organization, being closely connected and rooted with our people. There is also a need for us to renew our values and political culture by reintroducing meaningful initiatives to engage communities and serve the people. We need to encourage a culture of humility and modesty amongst our leaders. This practice of showing off to our people either our wealth, our cars as we drive in our communities must come to an end. The ANC serves the people. This NGC should elaborate on specific actions to be taken under each focus area. If the ANC can demonstrably renew itself, then public attitudes towards our movement will shift from cynicism to possibly cautious optimism and ultimately to absolute embrace and support. We have to earn that trust through our actions, not our words. The world is changing in unprecedented ways, with both challenges and opportunities for our country as well. It falls on the African National Congress to provide leadership. The brave women and men of the Congress of the People pledged to strive together, sparing neither strength nor courage until democratic changes set out in the Freedom Charter have been won, struggling together side by side. That remains our solemn commitment even today. We should now move forward to the complete realization of the National Democratic Revolution. And as we renew our movement, we should be able to get that support back from our people. It is now, as Madiba used to say, in our hands for us to renew and to rebuild the ANC. And we need to move forward to a united, non-racial, non-sexist, democratic, and may I stress, prosperous South Africa. I thank you, comrades.
Ramaphosa re morata kaofela re tsamaya le yena we molo 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 Ramaphosa re morata kaofela re tsamaya le yena we molo molo
Amandla. Amandla. Upresident usinike into ekuthiwa yi-political report, not just the political overview. He gave us the political report for the period. So after we've adopted the credentials, you will have to adopt this report as well. Now, time is against us, but we must do this. We must allow messages of support to be read now. Z6. No, Mamelan, Z6, we have 3 alliance partners, we have 3 liberation movements that have sent people here who are having a presence. So we allow Isango to speak first, followed by COSATU, followed by the Communist Party. Those are our allies. Then we'll come to the liberation movements. Sango, where is COSATU? Sondela Chazingi. Sondela Zingi. Ube solandela party.
Thank you very much, Chairperson, President of the ANC, Comrade Cyril Ramaphosa, ANC leaders who are present here, leadership of SANCO led by Deputy President, the President of COSATU, Comrade Zingisa, and other leaders of COSATU present. General Secretary of the SACP, although I've not seen him, Comrade Mapaila and other leaders of the SACP present. Leaders of the ANC Women's League, leaders of ANC Youth League, PYA, MDM structures present, and all the invited guests present here. Sinesiqubulo sethu kwisanko esithi asikhulumi ngesikuzwile, sikhuluma ngesikubonile, sikhuluma ngesikwaziyo. This National General Council of the ANC, Comrade President, is the constitutional imperative and a platform for the ANC to assess its work in the middle of the term of office of the National Executive Committee in between conferences, as you told us. The ANC adopted and instructed government to implement in accordance with the work of the ANC subcommittees. Lastly, it is the political program of the ANC to renew itself to become an even more powerful instrument to drive the transformation agenda. As we share our message of support to the ANC today, it is imperative to note that it is centered around the above three important points which are discussed below. As we share our message of support to the ANC on the assessment of the state of the alliance, we want to underscore and reiterate that this is not a paper alliance, as you said, and emphasized, President. Rather, it is an alliance forged out of the necessity to pursue a program that is meant to transform the lives of our people for better. It is therefore a revolutionary alliance glued on the program to pursue the national democratic revolution in order to resolve class, race, and gender questions. Therefore, whether dialectical contradictions prevail on the alliance relations, their synthesis should be predicated from the three important aspects of our revolutionary struggle: the class, race, and gender question. Hence, the following questions are important. How far are we with resolving the class struggle in our country in line with the national democratic revolution? What is the state of racism within the country, and how are we responding to it? What is the level of gender issues, including gender-based violence, in the country, and what is our response to it? Comrade President, Lenin, in his famous question on what is to be done, teaches us that posing correct questions lead to correct answers. Therefore, the above question should lead to correct diagnosis of the problems at hand and provide correct answers. The correct answers will also help us to understand whether it is the right time for us to entertain disunity, or we should close ranks against all forms of wage drivers, who, in my view, seek to weaken the ability of the alliance to pursue the national democratic revolution. Anything or anyone who contributes to the disunity of the alliance is actually derailing the NDR and contributing to counter-revolution. Using this characterization of the problem and without questioning the conference resolution of our party, the SACP, as an important ally in this alliance, I do not think that we must not engage on whether material conditions at this juncture allows for us to contest elections separately. If we allow this to happen, what will be the perspective of society of the ideological standing of the alliance, the NDR? I'm pleading with all of us particularly our alliance partner, SACP, that we perhaps allow space as allies to engage on this matter with the view to agree on compromises from all alliance partners. I therefore urge that we urgently convene the Alliance Summit to discuss and agree on the program and resolve our differences moving forward. We have a position on that. We are not going there to listen, we will engage. On the work of the ANC, both at organizational level and the government, this work is about service delivery, and it is very close to SANCO constituents. How we are assessed as SANCO by our constituents is highly dependent on the performance of the ANC-led government, especially delivery of service to the people. Therefore, the deteriorating socio-economic state of the country, which further exacerbates the triple challenges of poverty, unemployment, inequality, affect our work as SANCO severely, because we are on the ground to campaign for the ANC. This, as indicated above, has a negative impact not only to the ANC relationship with the people, but it affects SANCO's relationship with the people, because we rally them behind the ANC under the pretext of better service, delivery, and pursuit of the NDR. We are here to call on the ANC to not only review its strategy on delivery of services, but also to find quick and lasting solutions in order to regain the trust and support of the people. Lastly, on the question of renewal, apart from the delivery issues that we alluded above, the people of South Africa are aware that the ANC over years driven a vigorous program of transformation in the country. This includes all aspects of our struggle and touches in most of our Freedom Charter promises. This ranges from education, culture, land, laws, legislation, labor laws, comprehensive social security program, housing, water provision and electrification, infrastructure development, etc. We moved previously oppressed, mainly blacks, from 20 to above 90 in some aspect of delivery in this regard. Moreover, we commend the ANC for maintaining its political posture international and therefore making significant strides in fully participating in the global economic platforms such as the BRICS and the recent G20. Comrade President, we believe that the ANC has done well in this regard. However, the pace of service delivery must be accelerated in order to do more. As part of renewing the organization, we must look at the following 4 principles of running the organization, taking from Amical Cabral and through the eyes of the needle, the police of the ANC. The collective leadership, criticism and self-criticism to solve internal questions and contradictions, the democratic centralism, and pursuit of the revolutionary democracy. Long live Stalin and ANC, live. Long live SANCO, long live COSATU, long live SACP. I thank you. I thank you, Ubutung Sangabez, this child.
Mandla, Mandla, long live the African National Congress, long live. Long live the South African Communist Party, long live. Long live COSATU, long live. Ngandu Silwa Mhlali, Ngandu Silwa. Malibongwe. Gama lamakhosikazi. Siyabulela mqwathi. Ndibulise kumongameli we-African National Congress. Allow me, Chair, to rise respectfully on the protocol that has already been observed. Ndiyacamagwisha, ndiyathokoza, ndibulisa kubantwana bethongo. Chair, please accept our revolutionary greetings from the Federation of Elijah Bagai, the Federation of Nana Abrams. We are indeed honored to be here and look forward to the robust engagements, concrete commitments, and most importantly, the practical actions emerging from this critical NGC. We must, as the Federation, express our deep concern with the plight of our members, the staff of the African National Congress, who once again have not been paid on time, as this is their fundamental right. Comrade Chair, this cannot be tolerated. Workers must be paid without exception. COSATU expects this NGC to focus on the challenges that are facing workers and the unemployed. We need this NGC to focus on interventions to fix the state, to grow our economy, to tackle unemployment, to slash poverty and inequality, to address crime and deal with corruption. In order for us as the Alliance to win the coming elections, we must have a good story to report to society. This necessitates a progressive budget in February that will ensure that the state is able to provide the public and municipal services that the working class and the economy depends upon. We must revive the bold commitments that have been made in the ANC NEC January Lekgotla on a new mass industrial and small medium enterprises finance packaging. We must, as the President has alluded, ramp up the presidential employment stimulus to take the economy to the 3% that is needed. We must also be able to slash unemployment and provide a pathway to for the employment of 12 million people that are unemployed. We must also, Chair, move from talk to action. Abantu abaji amazwi ethu. And so we need to fix dire state of local government, and we must be able to overhaul our anti-crime strategies. Law enforcement and the judiciary must be provided with the weapons to win this war. Nkwati, what the working class does not want to see are comrades that are focused on factional destruction. 2024 and the 40% the liberation movement received is our final wake-up call. We ignore the warning from the working class at our own peril. This NGC needs to focus on intensifying the renewal of the ANC and the unity of the alliance. And we must say, only a coherent and united alliance can emerge victorious in the most difficult local elections to date in 2026. It is therefore essential that the Alliance Political Council be urgently convened, and that we must be tasked to ensure that the alliance is united as we prepare for the local elections. The fate president of the liberation movement and the alliance, the tools to fix the state and tackle crime and corruption, the ability to respond to the needs of workers and the economy lay within our hands. And so we want to say to the ANC, to the SSCP, to COSATU, to SANCO, the alliance is not a convenience. This alliance is a weapon, but a weapon that must be sharpened, a house that must be united. We must therefore resolve what divides us. We must strengthen what holds us together. We must win the local government elections, not for leaders, but for the working class. And so we are saying, it is up to us here collectively to rise to the occasion, to provide society the leadership it is so desperately seeks. And we dare not fail, because history will not forgive us when we do. And we want to say, as the Federation of Elijah Bahai, of Nana Abrahams, we will remain a tried and tested ally in this struggle. Thank you very much, Chair.
Thank you very much, National Chair. Must I also follow suit and stand on the protocol as it has been announced? First of all, I just want to indicate that the General Secretary is not with us today because there's a clash in our program. But we have prioritized this NGC because we have allowed him to go and attend to something, and the 5 of us are here as officials. All right, President, I just want to start, before I say anything, to start from the bottom. And thank you very much, and your government, for having convened a successful G20 conference. Not only about
Comrades, there must be order. Listen to what Comrade Masuk is going to say. You are in the NGC of the ANC. This is not acceptable. Be orderly. Sorry, Masuk.
Thank you very much. Thank you very much, and applaud you with the government for the successful G20 that we have just convened. It's not only about the G20 in our case. It's the innovation that we have actually put in that process of influencing the agenda of the G20. That innovation to bring about the social summit was spot on, because it was not influencing the G20, it was also influencing how also as government and the alliance we should take into account the issues that the summit has actually raised. One of the issues, because I spent time with it, one of the issues that I think they've been raising as a case was that we should stop talking about critical minerals. We must talk about minerals, all of them, because the minerals are part of them and they belong to the people of South Africa. Secondly, President, the party want to applaud you for having represented the sovereignty of this country. We have protected our image and want to say thank you. Your stance in relation to what we stand for as a country was communicated directly to anyone, to everyone else. And Comrade President, the G20, and that act, has allowed us to be able to realize that U.S. cannot dictate into the world
There are a number of alternatives that we can engage in terms of engaging our future. They don't have a hold in us. And for that reason, I want to thank you also for the initiative that you have actually taken to diversify your relationship with China, with all the other countries, with India, and all the other countries that you have been involved in. We're seeing you this week. We're in Mozambique. And we are saying, extend it to Cuba, extend it to Venezuela, extend it to Western Sahara. Comrade Chair, we are here to bring a message of support to our ally, the ANC. A trusted ally of the Communist Party. This trusted ally, over the years, we have worked together, we have set out agendas, we have done analysis, we have had some convergences, and in some areas, we disagreed. But in our disagreement hasn't resulted in us destroying and killing each other. Our disagreement has always been a strength, has tended to be a strength than a weakness of our work. And you can go back to a history all along. You can talk about the Black Republic thesis. You can talk about the formation of the military wing. You can talk about the strategy and tactic that we have adopted in Rogoro in 1969. All those aspects were a product of a contradiction that we're actually dealing with. But at the end, it has given us a way forward. And those are lessons that we must draw from going forward. And we must know that even today, we shall have contradictions sometimes in the analysis of what we are supposed to do and how we must go forward. This NGC theme is quite an interesting one. And I think it's very key to what the future is setting for us. The year of a renewal to make ANC a most effective instrument of the people to achieve the vision of the Freedom Charter. The people shall govern and the people shall share in the wealth of the country. Comrade President, this is profound. And we trust that this NGC, and we know that this NGC is going to reinforce this line in the resolution. But I want to point out, President, that the only problem that we have is that the current trajectory of our economic policy is going to be problematic to be in convergence with what is going to come out of this NGC on the basis of what you have pointed out. There is a need to sit down and review the direction that we're actually taking together, and not the ANC on the side and the party somewhere on the side and COSATU somewhere on the side. And we are agreed by the fact that not long ago, you have taken a very serious problem in terms of setting up our economic trajectory into the future. We are concerned, President, that we were not involved as a collective. And that agenda that you have actually said, Tina sees Bugedi. The last part that I want to talk to, Comrade Chair, the Communist Party welcome and support the agenda of renewal of the ANC. And our members of the party, who are members of the ANC, have been given a task to assist the ANC in this route that you want to do to renew yourself. But at the same time, we have gone as a party beyond that to say the renewal of the ANC and the renewal of the party as we have adopted it and the renewal of the COSATU is not enough. There must be the reconfiguration of the alliance itself. But, comrades, the reconfiguration of the alliance wasn't messed up by members of the party or the members of the ANC and the general members of COSATU. This discussion has been messed up by us as leadership because when members went into various conferences and said, move forward, we want you to conclude the alliance, the reconfiguration of the alliance, we dilly-dallied until the Communist Party took a decision to say, we are going to contest elections. And the contestation of elections, comrades, it is important, this aspect that I want to speak to, comrade, will assist you because this NGC is going to interrogate that. You have said initially here, the president said, and the president of COSATU said, we mustn't make our decision on the basis of emotions. We must listen to each other. We are saying, comrades, the decision to contest elections is not to contest the ANC. The decision to contest election is contestation of election. And this matter, comrades, is a very critical matter because it has to do with the existential being of the party. Because if the party cannot introduce socialism as a path, its existence will mean nothing. So these elections are meant to do that. And as I close, Chair, our members will be on the ground assisting the ANC to strengthen itself as members of the ANC to win elections. But at the same time, they've got a task of building a socialist movement, and they will be driving that socialist movement to elections. Mandla!
Amanda, away to Molo and Sophie. Molo and Sophie. Molo and Sophie. Molo and Sophie. Okay. Mamelani ke. Mamelani. The most important thing about a gathering of this nature is that you listen to what you like, you also listen to what you don't like. You have a duty to listen to every view. Now, we have a contradiction in stand up now because the translator into forward mobility. Before we break for lunch, sizawucela the following comrades abathunywe ziipati zabo. John Lukando weSwapo. Niyazi iSwapo? YaseNamibia. Comrade Lukando uzawulandelwa nguComrade Sithembiso Nyoni weZANU-PF ngapha eZimbabwe. Niyazi ZANU-PF? Oh, nambalwa ngokabayaziyo. Then kuzawuthetha uST weFrelimo, uComrade Chaki Abubakar. Ezo ziliberation movement ezithumele members of the Central Committee to this NGC. Thank you, comrade.
Thank you very much, Program Director and our National Chairperson of ANC, Comrade Ngwende Simpson Matashe. Samson, thank you for correction. The President of ANC and of the Republic of Namibia, of South Africa. The President of ANC and President of the Republic of South Africa, Comrade Cyril Ramaphosa, the Vice President of ANC and the Republic of South Africa, Comrade Paul Mashatile, and of course the Secretary General of ANC, Comrade Fikile Mbalula. Comrade Chair, in the interest of time, I recognize the rank and file of ANC as well as the salutation established earlier. On behalf of SWAPO Party leadership, we wish to extend our word of gratitude and well-wishing to the entire membership of the ANC and the people of South Africa. The President of SWAPO Party and that of the Republic of Namibia, Her Excellency Netumbo Nandi Ndaitwah, on behalf of our liberation movement, SWAPO Party, acknowledge and highly appreciate the invitation to this generous historic event of ANC. In the same vein, Honorable Chair, Comrade Chair, I wish to extend a sincere apology from our Secretary General, Comrade Sophia Shaningwa, whom I personally standing in for. She wanted to be part of this historic gathering, but due to pressing commitment back home, as a week ago we had a historic regional elections and municipal where her commitment is required in terms of deployment and secondment of elected office bearer to the second and the third tier of our national government. Therefore, accept her apology. Your Excellency, Comrade President, this noble invitation and convening of ANC National General Council coincide with our freshly ended regional and local authority elections, which was held on the 26th of November 2025, on which our governing party, SWAPO, through the election with close to 70% victory in both regional and municipal elections. Therefore, this trajectory victory signifies the trust and loyalty to the people of Namibia, our former liberation movement, SWAPO Party. Therefore, our attendance at this gathering came at the right time as we prepare to take a post-mortem of our freshly ended elections, as well as preparation of our induction training programs, as the new office bearers will be deployed in key positions at our third and second tier of our government. Therefore, the 4-day session will serve as an introduction to our induction program as we go back home. Our SG opted to send 2 representatives to come and tap wisdom from these noble gatherings. Comrade Chair, I'm therefore accompanied by an esteemed member of Parliament, who is also the deployee of the working class, the National Union of Namibian Workers, NUNW, in the name of Justine Jonas. She's there. Comrade Chairperson, we view the hosting of this event as a true reflection of good governance and acting on the will of the people and the entire population of South Africa. This event, under the theme renewal to make ANC effective instrument of the people to achieve vision of the Freedom Charter, and people shall govern, and the people shall share the country's wealth, speaks a lot. To conclude, dear comrades, on behalf of Namibian people, our president wishes equally to extend the position of South Africa on hosting the G20, which ended up successfully with several declarations, and wish to confirm that Namibia as a country, we stand together with South Africa without fear or favor on both declarations. We equally also thank South Africa for hosting the just ended SADC-PA forum, which was also officiated by the Vice President, Comrade Paul Mashatile, in KZN, of which I was also part of. To conclude, we wish also to congratulate the ANC for its performance during the recent by-election that was held countrywide in South Africa. That shows the trust they have. We wish you the best of all as we move closer to the mass-based outcome and resolution of the 5th General Council of ANC that will provide new energies and result guidance with our organization and established structure. Aluta! Aluta! Maibuye! Thank you, Comrade Chairperson.
Thank you. Zanopia, it's your turn now. You're wondering, is this piece of Gabalong?
Long live President Cyril Ramaphosa, long live! Long live President Iti Mnangagwa, long live! Viva ANC, viva! Viva ZANU-PF, viva! Phansi ngabasizondayo. Comrade Matamela Cyril Ramaphosa, the President of the ANC, kindly allow me to write on the protocols already established. Your Excellency, President Ramaphosa, I come to you carrying special revolutionary greetings from your brother, your comrade in arms, and your lifelong ally, His Excellency, the President of the Republic of Zimbabwe, and the First Secretary of ZANU-PF, Comrade Iti Mnangagwa. Uti ninjani? I convey greetings from ZANU-PF to the ANC and the people of from the people of Zimbabwe to the people of South Africa, declaring that we are one people bound by a history that spans centuries and decades and sacred blood of our people. Comrades and friends, my delegation and I are most grateful, Your Excellency, for the hospitality we have received from the people of South Africa. We want to say thank you very much. Siyabulela. This reflects our profound and unbreakable relationship between ZANU-PF and ANC. Ours is not an ordinary relationship. It is bound by the trenches where Zimbabweans and South Africans fought side by side, shedding blood for the liberation of our people. That history is sacred. That solidarity is unshakable. We are one people. We share one vision, economical and political prosperity of our nations. Freedom Charter, though born in South Africa, is ours too. It inspired the whole continent of Africa. It spoke to the dreams of the oppressed Africans. It remains a guiding star for every progressive liberation movement that seeks dignity, justice, and economic emancipation of its people. Comrades and friends, from the powerful address delivered by President Ramaphosa yesterday and the panel discussion that followed, we had the same language that resonates across liberation movements. That is self-reliance, nation-building, and sovereignty. We congratulate you, President Ramaphosa, and the people of South Africa for your leadership and that of the ANC, for the economic achievements and the registered economic growth despite all the challenges. In Zimbabwe, our president always says, "Nyika inovakwa neveni vayo, ilizwe lakhiwa ngabanikazi balo." A country is built by its people. This is exactly what the ANC is doing. Congratulations, Your Excellency. We commend the progress made towards fulfilling the Freedom Charter. As President Ramaphosa highlighted yesterday, your work is re-attracting the youth to the movement, demonstrating that liberation movements don't belong to yesterday. They also belong to generations to come. You are empowering young people and women, giving them space not only to participate, but to lead and to shape the ANC and drive the national agenda and to own the future of this great movement. The ANC is the future, just as ZANU-PF is the future in Zimbabwe. We have made the ANC, you have made the ANC attractive, Your Excellency. Again, a movement of ideas, solutions, hope, and renewal. With these achievements that you continue to register, we say with confidence, the ANC is leading today and will continue to lead for generations to come. Finally, comrades and friends, allow me to salute the people of South Africa under the stewardship of President Ramaphosa and this colossal revolutionary party, the ANC. Your voice on the international stage has become the voice of Africa. Your membership in the G20 and the BRICS is not only for South Africa, but for the whole continent. On behalf of His Excellency, the President, Dr. Emmerson Mnangagwa, and ZANU-PF, we reaffirm our support to this and our solidarity and our shared commitment to the liberation ethos that binds us. I would like to wish this Congress the greatest of all success. As your theme goes, indeed, the people will govern. The people will share the wealth of their country. Long live ANC, long live. Phansi ngabasizondayo. Ngiyabonga.
Viva Frelimo, viva! Viva ANC, viva! Thank you. Camara Chair, Camara President, allow me to speak in Portuguese. I have this boy here will help me in translation, please. Camarada Presidente Matamela Ciro Ramaphosa, Presidente do ANC e Presidente da África do Sul, I say, Comrade President Matamela Ciro Ramaphosa, President of ANC and President of South Africa, Comrade Paulo Mashatile, Vice President of ANC and Vice President of South Africa, my brother and my Secretary General of ANC, Camarada Fikile Mbalula, all observe the protocols, dear comrades. Now I'll start in Portuguese. Allow me, permita-me que, em nome do camarada presidente Daniel Francisco Chapo e em nome da Frelimo, possa me dirigir a esta importante reunião.
Allow me, in the name of the comrade President Daniel Chapo, to address to this conference.
Em nome da Frelimo, queremos expressar a nossa profunda gratidão pelo convite e pela oportunidade de participarmos neste importante encontro.
In the name of Frelimo, we want to express our profound greatness for the invitation for this meeting.
Esta reunião acontece no momento em que, em julho passado, realizamos a Cimeira dos Movimentos Libertadores da África Austral.
This meeting happens in a year that in July this year, we had a summit of the liberation countries of Africa.
Onde, de forma profunda, discutimos os desafios que temos aqui a nível da região.
In a profound way, we discussed the challenge that we have here in the region.
De forma particular, gostaríamos de saudar o ANC por organizar este evento e, de forma especial, na celebração do 60º aniversário da Carta da Liberdade.
In the formal way, we would like to congratulate ANC to organize this meeting and also to greet them for the occasion of the 7th anniversary of the Freedom Charter.
Este documento não só guiou a luta contra o apartheid, como também inspirou inúmeras gerações de África.
This document, it was not only the struggle against the apartheid, but also inspired countless generations across Africa to believe that political freedom must work side by side with economic justice and social equality.
That's it. A Carta da Liberdade permanece farol que continua a orientar todos que, com a Frelimo, acreditam numa África igual, desenvolvida e soberana.
The Freedom Charter remains a beacon that continues to guide all those who, like Frelimo, believe in Africa that is equal, development and sovereign.
Por isso, quero tomar esta oportunidade para saudar o camarada Ciro Ramaphosa pelo sucesso do G20.
That's why I would like to take this opportunity to congratulate Comrade Ciro Ramaphosa for the success of the G20.
Não há dúvida que este sucesso reafirma o compromisso do ANC em implementar as principais decisões da Carta.
There is no doubt that this event reaffirms the compromise of ANC to go forward with later.
Queremos igualmente agradecer e saudar a visita a Moçambique.
We would like also to congratulate and thank for the visit in Mozambique.
Foi momento ímpar da nossa história.
It was a single moment in our history.
Como vizinhos,
as neighbors,
devemos trabalhar juntos para desenvolver os nossos países.
We have to work together to develop our countries.
As fronteiras que existem,
the borders that are alive,
foram impostas pelos outros.
They were made by others.
Nós somos único povo.
We are one people.
Por isso temos que continuar a trabalhar juntos.
That's why we have to continue working together.
Por isso é que gostaríamos de saudar esta reunião.
That's why I would like to greet this meeting.
Em que a ANC junta pretende, de forma profunda, discutir de forma aberta os desafios da atualidade.
That ANC together wish to discuss in open way the situation of the ANC.
Quero reiterar o nosso compromisso, o compromisso da Frelimo e do presidente Chapo em continuarmos a trabalhar juntos.
I would like to call up the compromise of Frelimo and the President Chapo to continue working together.
A vitória do ANC é a nossa vitória.
The victory of ANC is our victory.
Por isso é que temos que trabalhar juntos
That's why we have to work together
para vencermos os desafios que nós temos.
to overcome the challenge that we have.
Os tempos não são fáceis.
The times are not easy.
O inimigo do passado permanece forte.
The enemy of the past is stronger now,
Com outros métodos
with the new methods,
mais sofisticados,
more sophisticated,
influenciando a juventude,
influencing the youth,
usando o sistema financeiro,
using the financial system,
algumas organizações sociais
some social organizations,
para retirar os partidos, o movimento libertadores do poder.
to take out our parts and power.
Por isso temos que trabalhar juntos
That's why we have to work together,
e temos que estar unidos.
and we have to be united.
Permitam-me terminar,
Allow me to finalize,
porque muito já foi dito pelos que me antecederam.
because a lot have been said for the ones that came before me.
Permitam-me terminar deixando aqui, partilhando convosco, 3 importantes mensagens.
Allow me to finish sharing with you 3 important messages
que normalmente como africanos chamamos de provérbios.
That normally as Africans we call it proverbs.
O primeiro,
The first one,
que é moçambicano,
that's Mozambican.
diz o seguinte:
It says so.
só se come açúcar
You only eat sugar
com quem comeste sal.
with the ones you ate salt.
Isso é muito importante
That's very important,
para que a gente não se esqueça daqueles que trabalharam conosco nos momentos de dificuldade.
so that we don't forget the ones who used to walk with us in the struggle moments.
Temos que estar juntos até hoje,
We have to be together until today.
no momento da bonança,
Where is the time of abundance?
para juntos partilharmos as nossas conquistas.
So that together we can share our conquers.
O segundo,
The second,
diz que quando não existe um inimigo no nosso interior,
it says that if we don't have enemy inside,
os inimigos de fora
the outside enemies,
jamais conseguirão nos derrotar.
they will never defeat us.
Isso é importante,
That's important,
porque reforça a nossa união,
because it reinforces our union,
a nossa coesão.
our cohesion.
Por mais que tenhamos problemas,
Whenever we have problems,
por mais que tenhamos desafios,
even we have challenge,
nunca devemos colocar em causa a nossa união.
we never put in curse our union.
Nunca devemos colocar em causa a nossa
We
coesão.
never put in case our union.
O último provérbio,
The last one, the last proverb,
acredito que se assemelha do que se diz também cá na África do Sul.
I think is almost the same with what they say here in South Africa.
Não importa quanto longa seja a noite,
It doesn't matter how long is the night,
o dia certamente virá.
for sure the day is going to come.
Pelo que percebi aqui,
With what I understand here,
tentando traduzir,
trying to translate,
Jesu afika kusene.
o Jesu fica kusene.
É importante
It's important
que todos percebamos,
that we all understand,
por mais que sejam grandes nossos desafios,
whenever it's a huge our challenge,
ainda há esperança do dia de amanhã.
we still have hope for tomorrow.
E é importante
And it's important
que permanecemos juntos e unidos.
that we remain together and united.
Queremos mais uma vez dizer muito obrigado por essa
We'd
oportunidade.
like to say once again, thank you very much for this
Em
opportunity.
nome do presidente Chapo e em nome da Frelimo.
In the name of President Chapo and in the name of Frelimo.
A luta continua!
The struggle continuing.
A luta! A luta! A luta! Long live President Cyril Ramaphosa!
Long live
Long
President.
live President Chapo!
Long live.
Thank you very much.
Obrigado. Thank you very much.
utya ngoku. Asundilawula ndiphethe apha. Ndiphethe apha ngokona. Mamelani ke ngoku. We're all going to break for lunch. But before we do that, let's acknowledge the following people. The Communist Party of Cuba. Send a message, and the ambassador of Cuba is here. The State of Palestine, send us a message, and the ambassador is here. Okay. Viva! Ipolisario Front. Ndiyayazi ke kuthiwa Polisario Front anizuyazi. Uninzi lwenu zange niye dirhla. Zange niye dirhla. Is a Western Sahara. Isithumele message and ithumele ambassador. Venezuela is a foreign minister. Ambassador. Hlalani phansi. Hlalani phansi, hlalani phansi. Ningavi ngaba basemva kwami. Kuphethe mna apha. Venezuela, despite the siege under which President Maduro is, send an ambassador here from Venezuela. Now, at least Trump has confessed that if Venezuela has more oil than anybody else, has more oil even than Saudi Arabia. So that is really the issue that is there. Okay. Then let's acknowledge the following ambassadors as Koyo Abba. Algeria ikona. China ikona. Egypt ikona. France ikona. Iran ikona. Nicaragua ikona. Russia ikona. Singapore ithumele ambassador. United States of America ithumele umuntu apha. Ayikamna ambassador kodwa ithumele umuntu imelwe apha. United States of America. Vietnam ikona. FES Frederick Ebert Stiftung ikona. Young Women of Africa. Young Women of Africa. And Wabun. Okay. Center for Africa Strategy in BRICS. Okay. So we're acknowledging everybody. There's one thing that is important, including alliance partners. you are going to participate fully in the commissions. So you have an opportunity to argue your point in the commission. There would be no chairperson like me to protect you there. If you say things that make people angry, you may be thrown out of the commission. I have no control over that. Yeah? Okay, let's do this. Let's break for lunch. Mamela, before you announce him and Ted, Nizabalapa at 3:30. Sinika an hour and some minutes because Nibaninzi. Nomvula announce a venue the lunch. Okay.
Amandla, thank you very much, National Chair. The following are the venues for delegates, for guests who are going to be guided by the protocol representatives that have been assigned to our allies and to the guests that the National Chair just acknowledged. The OR Tambo Hall, Free State, Eastern Cape, Gauteng and Limpopo. You will have your lunch at the OR Tambo Hall. And next to the OR Tambo Hall, which is the Clovers Green, it's Mpumalanga, Northwest and Northern Cape. Then opposite Clovers Green, Serengeti, you have the Western Cape and KwaZulu-Natal. Lunch for NEC and former NEC members will be in Cape Town in the International Center, right on the opposite side. And then lunch for Veterans League, NEC, as well as our international guests, will be at King Shaka International. Thank you very much.
Kan mamelani yabona ke kweza indawo niswa kuzo eziprovinsini nenza lento ukuphuma kuthethwa akathi waphumani kuzacacisa indaweni yakuzo then kuzawuthiwa formally kwajeniwe nakubuye ngo-3 molo bata